today are the addendas that are attached to the contract in paragraph 22 or through an amendment. We're going to talk about notices because those are different than addenda. They're a notice. A notice is usually required by law, and so that's why we have to present notices. And then amendments. And what happens, because I have until 10:50 to do this training, it's lasted over 3 hours in the other market centers when I've given it because of all the questions. So what I'm going to do is the first thing we're going to cover is amendment. I usually save the best till last, but I'm afraid we're going to be running short on time, and I want this to make sure that we do cover that. Some of the addenda that we might miss might be addenda that are used with the contract, but not often. We use the most common ones, so we're going to talk about that. The reason addendums are so important and that why we're going to talk about them is that they require sometimes performance by either the buyer, sometimes performance by the seller. Just depends upon which addendum that we're working on. And what you must remember is that all those dates and all those trigger time limits in these addenda, you must have them front and center and be paying attention to, because in many of the addenda, if that date passes, the contract automatically terminates. And we've had several instances in the last few weeks where a buyer agent failed to pay attention to that, and the seller said, we don't have a contract. And the only person they're going to blame is the buyer agent. Our clients are not used to using these forms. Number one, they don't read them. No matter how many times you tell them, please read this before you sign, they don't do that. They are solely relying upon you as the professional to know what's next, what should I expect, that type of thing. So that's why it's very important. Now, we're going to go through amendments, and I think it's the last thing on your, last thing on your little handouts. See, so all you have to do is go like this, and we'll start there first, and then we'll go back to the front of it. Okay, what is an amendment? Pardon me? An attachment? Okay.
Changing something in the contract.
Changing. Adding. It's a part of the contract. It amends the contract. It adds to the contract. This amendment could also be taking away a provision of the contract, could be changing the terms, could be changing dates, but it's a part of the contract. Do you think it's important to have an executed date on an amendment? Yes. Really? Yes, I think so. And what happens is, because we digitally allow individuals to electronically sign, and there could be date stamps with their electronic signatures, we get really lazy. Well, we think, okay, well, we got a date here and we got a date there, so why do we need to date it? Make no mistake, the only people who will be blamed for not executing an amendment will be the agents, because you're the only ones to do it. God bless you. So you don't receive an amendment fully signed, without an executed date. Otherwise, you pick up the phone and you say, we have an executed date on this amendment of today. Don't let it go. It has to be timely, okay?
You said you put it in writing in an email and have the other agent, the other party agree to that, the executed date.
Yeah, but you most of the time we pick up the phone and talk to them, and then we confirm everything in an email. We don't do anything without an email. Yes, sir?
So if you have a fair amendment and all these are addendums, what's the difference?
An addendum is an addition to. In other words, an addendum says, here's the contract, now we're adding this addendum, additional part that will also be a part of it. Instead of another paragraph, it's an addendum that might have more provisions than a paragraph might have. But it's an addendum to the contract. It's been added to the contract as well. An amendment can change it rather than just adding to, because our amendments sometimes add things too, but this amendment can change, modify, add, and delete. So that's the big difference. Addendums that we have are very specialized because an issue has arisen in this real estate transaction, and they said, well, let's put some terms together where the parties could agree to it and have an understanding of the performance. And so that's really what the addendums are. Most of them are driven by statute, by law, because the law says you must do this, and so they created a form for which a seller could present information to a prospective purchaser. But on this amendment, it's very important because if you read your amendments out loud, nobody would sign them. Because if I can't understand them, the parties to the contract can't understand them. Many times, things are written in there that really are, you're making a statement rather than an action that the parties wanted to agree to. So you don't have a lot of liberties to be creative, just like we have in special provisions in the contract. We can't do a lot of things. One of the agents said that next time he sees something in special provisions, he's going to call me. I just want you to know what's going around. The attorneys for several RE/MAX operations, they have gotten together and said, okay, well, we're going to give this language to the realtors and say, you know, if your client puts a lot of cash into a down payment on the property, then you better add this for the client in special provisions. And it's a language talking about how this buyer has the ability to terminate if the property doesn't appraise and all these different things. We just had a fight, and the RE/MAX agent told the Keller Williams agent, she said, Trek said that has to be in there. And she called me Saturday evening at 9:20. And she says, Marilyn, this RE/MAX agent is saying Trek said that we had to add that. I said, really? Well, if Trek said we had to add it, Trek would have added it. I said, they're making that up. Somebody is coaching them to try and see if they can get a provision to allow a buyer to terminate in the event it doesn't appraise. And what do you think on Monday happened? The other agent said, oh yeah, the attorneys for Trek, they wasn't a Trek. She said it was our attorneys for RE/MAX told us to add that. And I told her, I said, you tell your seller that they now have to get an attorney to interpret what is being presented by this buyer if they want to respond to it. Otherwise, what will they do? They will strike it and not allow it. And what she conveyed to the buyer agent on Monday was the seller said they're not going to hire an attorney to interpret this, and they struck it out. If you'd like to resubmit without that, it'll be fine. So what happens is we're seeing a lot of things. I mean, this is coming from Martha Turner's agents, Greenwood King, all of this. And I am going to tell you, your board liaison, that is your attorney for your local boards, they have all written white papers that say you don't write contingency language. Be very careful. That is a violation. And Trek is giving you a break by giving you a warning. But I'm going to tell you that you're never going to write, if this happens, then this is what happens. We don't write that. Only attorneys do, because it's legally enforceable. And if I said it to a client and said, let's put this in here, there's no enforceability. And the contract could go to a court to decide. Well, we're not going to already have a court deciding a dispute. We're going to be very clear about what we communicate. This amendment is like a host for this bacteria and this virus. You had very limited area in the special provisions of the contract, and your hackles are up and you know, let's not do that. When you come to the amendment, it's like you threw it all away and thought, oh, well, we can just do anything. Because, see, we have to negotiate either the condition of the property or we have to negotiate this type of thing. So it's really scary when I see these amendments drafted and I don't know what the parties have to do. And if I don't know, then I am almost certain that the buyer and seller don't know what they have to do. And what's interesting about this amendment in our contract is that instead of you trying to interpret and say, I know what should be done, when a party says, well, I want this, and you're going to say, where in the contract does it state that? Can you point to it? If you can't point to something, most likely it's not going to apply. Okay, and that's what I mean. We have a lot of provisions that take care of a lot of situations. But if a buyer or seller is saying, Well, that's what I think it means. Well, that's not what it is. That's not what the parties agreed to in writing. So be very careful. In an amendment, we have several paragraphs, and we're going to go through each one of them because I want you to be familiar with them, and I want to introduce you to a couple of them that I don't think you've ever seen. Number 1, seller and buyer amend the following. Okay, it says they're amending the contract. Number 1 is paragraph 3 of the contract. So the sales price is going to be now modified based off of paragraph 3, and it's A, B, and C. Okay? Now, you don't have a calculator here. So in the event you're in the option period and the parties agree to negotiate a concession and a reduction in the sales price, make sure it adds up. Okay? Just be real clear on that because you are proficient in math. Trek told me so. Number 2, in addition to any repairs and treatments otherwise required by the contract. And where would that be? In particular, paragraph 7D2. At the time that the buyer made their offer, they got the seller's disclosure in hand, and they saw all these broken windows. They saw broken tiles around the pool. All these things the buyer saw. And the buyer says, I'm not going to say I'm going to take your property as is. I'm going to amend it right off the bat to say I accept it if you do the following things. And what happens on that in paragraph 72 is it prepares the seller. The seller now, if it accepts the contract and accepts whatever is negotiated in paragraph 72, the seller knows they have to do that no matter what. No matter what. It's not about what happens later. It's what the seller has accepted. In paragraph 2, it says that in addition to any repairs and treatments otherwise required by the contract, seller at seller's expense shall complete the following repairs and treatment. Highlight my part. Be very clear and exact. If necessary, attach an exhibit for clear explanations and instructions and greater acceptance by each party. Now, in my world, I live in a really nice world of real estate. We don't do anything that has conflicts or concerns. But your world of real estate is filled with that. That's what you're doing all the time in your transactions. So it's very easy for me to say, this is what we do. But in this event, if the buyer wants to negotiate a condition of property for a seller to either repair or replace or treat, it better be so clear that the seller could use it as a checklist for the individuals, the professionals and licensed contractors that they hire to do that work. You see what I'm trying to get you to understand? It's going to be where the seller can point and said, I did this, and the buyer can point and said, you didn't do this. That clear. When you have these rolling paragraphs of things, it just isn't clear. Do you know what I'm saying? So make a conscious effort. If you do have a party that really wants to negotiate condition of property, or they have to negotiate it because their lender may require it or that type of thing, make sure that it's very clear. 1, 2, 3. And if you go past one page, rethink that. Yes. I really think as long as the buyer has a clear understanding of what they're asking the seller to do, and it reflects, the inspection report will reflect something very clear that the seller has to do. I don't want to leave it open to interpretation. A lot of times they see this paragraph and it says, hire an HVAC to review it. It didn't say anything other than to review it. It didn't say fix it if it's not in good working order. Do you need to say all those things? That's where my concern for you comes in. While that inspector provides a format that is required by TREC for them to follow, a lot of times it leaves it up to interpretation. Well, exactly what does the seller have to do? And we've been stung by a seller pointing out, what you wrote in there was not to ask me to repair or replace anything that the HVAC inspection revealed. And that hurt the buyer. It hurt the buyer agent even more. So if they want the coils cleaned, or if they want the coils replaced, or if they want the duct work, or they want the airflow to be at certain pounds per square inch, all these types of things, they have to be very, very literal. Yes?
Say, for example, on the seller's disclosure, there's a mark on there saying something to the effect of like, there's a little shift in the pool, okay? But then and you write the contract as is, and like you mentioned, it's just checked in the contract as is. Well, then the inspector comes through and realizes that the little shift is actually causing a leak and it's a big problem. Is it appropriate to ask for them to repair that based on the seller's or the inspection reports? And the listing agent was saying, no, it was in the seller's disclosure, we disclosed this.
Well, a seller's disclosure is required by law to disclose. It has nothing to do with the contract. It's not a part of the contract. And while that buyer may have had knowledge, I feel like that buyer, I'm not a pool specialist. I'd have no idea if that's a problem or not. I'm going to tell you, I've been to a lot of inspections, haven't y'all? But I'm never going to be the authority saying, don't worry, that's not a big issue.
So what is that sort of request the listing agent? No, we disclosed it, then
Well, you may have disclosed it. Now the buyer is going to be negotiating the condition that they actually independently verified, and it says so in that paragraph 7 that that does not preclude them the right to do inspections and negotiate. So, how many of you are listing agents in this room? Raise your hands, tall and proud. You list to last, okay? I'm not meant to offend you, but sometimes when you sit on a throne and you cast down things to these lowly buyer's agents who have brought a ready, willing, and able buyer to your seller's property, you better just remember everything you say will be held against you. And I've got it in some emails, and I will hold it against them. They do that. In particular about, don't send me that inspection report. We have one of the top teams in the city who sent that email, and I've got a copy of it. And I'm just going to hold it until I need to use it. And then I'm going to bring it out. I'm really very serious about this. I have a really difficult time. These are buyers and sellers. We don't have a big shield up. But what we do have is a lot of experience and knowledge. That's what we should be holding high, not a shield to say, don't do that. Look, it's between the buyer and the sellers. You two are facilitators at this point, and you better learn that there's a proper protocol and that your language is very damaging. Because as a buyer's agent, when that buyer agent got that email from the listing agent, what did they have to share it with? The buyer. So now the buyer is calling and saying, I'm filing a complaint. This is outrageous. I'm going to take them down and they're never going to be in business again. This is how they work. And probably we have proof to show that they do work that way. Okay, so just be very careful. That's what I'm trying to get through to you, is that you don't sit on a throne. You're a facilitator in behalf of your seller. And where your weapon is your knowledge and your experience. Okay? In this paragraph, too, they gave us very little room, very similar to how we have in special provisions in the contract. So most of the time, you're not going to be able to have a buyer be very clear and concise about what they're asking the seller to do. So you're going to probably have to say, see attached Exhibit 1. And then Exhibit 1 now becomes a part of this amendment because you've attached it in this paragraph. Most of the time when we see those exhibits, my heart kind of sinks because now I know the agents are going to have to supervise all these repairs, and I don't want you in that business. That's disastrous. Because are any of the repairs ever done to the liking of the buyer? Rarely. Do you know what I'm saying? They'll walk through after they get the receipts prior to closing, and they'll go, no, I don't like the way they did that. I'm not closing. And there's the seller going, what? I'm ready to close. So again, be very careful. Yes, sir?
Something that might help on that front is the action pictures of him gets very specific about, what's acceptable in drywall, what's acceptable in brick. And it may be useful to at least become familiar with it, and you could reference that repairs be done to the following standards, rather than, fix that drywall for the very reason that you're saying.
Yeah, it's drywall, touch-up paint, any types of things are very difficult. We just got sued over some of the issues you're talking about. And one inspector notated these standards, which had no bearing on the property in question, and our attorney had to spend thousands of dollars to research that. So you have to be kind of very careful. We don't use information from other sources. We're truly a facilitator between the buyer and the seller. And anytime we get into cosmetic kind of issues, that's pretty difficult to try and please all parties. I would rather a concession either off of the sales price, which won't put any money in the buyer's pocket, but it gives them the monies for that negotiation, or in paragraph 12 that we're going to talk to in paragraph 4. But again, when I'm talking about the exhibit, I want it very cleanly done, very clearly. Many times the agents that are tasked with more repairs or issues, they place initials by every one of the numbers. Like 1 will have a set of initials, number 2, 3, 4. And then what happens is that it makes it a little easier for a buyer and seller to really negotiate and clearly see that, yes, I accept this, or no, I'm striking this through, I'm not going to do 2 on this attachment. And my concern is that we just want something real clear, very clean, not scratchy, not trashed up, that the parties could point to. And the seller could say, I hear you, listing agent. I know I have to hire a licensed professional. I understand this, and I'm going to hire the licensed professional, and I'm going to hand them this list and say, do items 2, 4, and 7, because those were all electrical. And provide an invoice. This is the next part for you listing agents and buyer's agents. Provide an invoice that actually has a line item that directly correlates with what the parties negotiated and agreed upon. That's the best way. Some of these invoices that we get, I read them, and they didn't do what the seller was asked to do by the buyer. And a listing agent has grabbed it, passed it along, and the other party has passed it along. Everybody went to closing and funding. And guess who reads it after it's closed and funded? The buyer. So our goal is to, when the parties really want to facilitate the condition of the property, you really need to go in high gear about a skill set so that it's clear, clean, and understandable. In other words, it's not subject to the interpretation. It truly says they will repair this, they will replace this, they will have an inspection report. In the event that the inspection report notates that something needs to be repaired or replaced, seller will do. Do you see the difference? So just saying, have an HVAC inspected, that's a line item for a seller. They have them inspected, and the HVAC guy comes back and says, oh my gosh, this system is only going to last another week, or it's on its last leg. And the seller says, I don't care, I'm selling this. And they don't tell the listing agent. It all comes out usually after closing, because the buyer takes that invoice, they call that vendor after closing, and the vendor says, that's okay, I told the seller that, and the seller told me not to put it on the invoice, that it wasn't in good working order and it needed to be replaced. And they said, don't worry, because we're selling it. And if you think I've made that up, you're wrong. That's exactly what we were dealt with. Not much of a defense on that one. And then the seller says, no, Keller Williams, you fix it. You listed my property and you got the commission, you take care of it. Am I saying things that are not true? No. I just want you to be prepared, because this is really probably the most abusive piece of paper I see when I see compliance, is that it wasn't well facilitated among the parties. And if I represent the seller, do I have a fiduciary duty to be fair and honest to the other party? Oh yeah. Mm-hmm. So that means if the buyer agent made a mistake and I saw that, am I required by the code of ethics to bring it to their attention? Yes. And the seller will say,
bring it to their attention if they said just have it inspected.
No, I'm talking about something that they might have made a mistake on, transposed numbers. You had a previous conversation where you agreed to something, or an email where you agreed upon it, and then when it came to you in the final form, you could tell that they made a mistake. You don't get to sit and say, oh, gotcha. Your code of ethics doesn't allow you to do that. And it's not harming the other party, because our job as an agent acting in behalf of another person, is that other person said, you know, Marilyn, I will give them this and this and this. Okay, so now I have a checklist of what this principal I represent told me. Now it is my duty to take what the principal told me to do and place it so that all parties can agree to it in writing. That's my job. And where I've nailed the agents the most is we have in an email exactly what their principal told them to do and identify, and they didn't do it. That's how we get now. You don't get to say, no, I'm not going to do that, I'll wait later. No, if your principal tells you to do it, this is what you're trying to facilitate. And it's interesting, the party I nailed was a buyer who was an attorney. And the agent who represented this buyer thought, well, we can take advantage of the seller. They didn't do this, so now we can act like this. And I went straight to the buyer who was an attorney, and I asked them, I said, what is it exactly that you had agreed that your agent would place in an amendment for all parties to agree in writing? And he acknowledged that that wasn't done. And he acknowledged that the buyer agent was trying to do one on the seller. And that's when the broker's an intermediary. That's how I know these things, because I found out from all the sources. We're going to get to the bottom of it, because it truly is about the parties and what they agreed to. And so the attorney had to agree that his agent had manipulated something to his advantage, and the attorney was a part of it. And the attorney stopped immediately. It's really difficult for you to do that when you represent the parties, because they're looking to you and they usually want the confidence and that type of thing. But when it came down to a big dispute, we were either going to be in a court and somebody was going to reveal all this. This is not a secret. It gets revealed. It's just, it's sooner rather than later that we're going to do that. So again, does everybody understand? If the parties really want to facilitate for the condition of the property, you're going to have a very clear understanding. Mr. and Mrs. Buyer, what exactly do you want the seller to do? Do you want the seller to replace this, or do you want the seller to repair it? Most of the time, we find out that it cannot be repaired, right? The parties agreed to repair it in the amendment. Seller finds out it cannot be repaired, it can only be replaced. And the seller goes, well, I did what I could. Listing agents, you better beware. That seller was specifically required, per this amendment, to repair it. If it cannot be repaired, you have to go back to the other party and tell them so. And then further negotiation would happen from there.
Now, what if people, they just put repair/replace, or repair and will replace, does that cover that?
I would think so. The poor agent that didn't use the word replace went down. Big time. Because sometimes things can be repaired to the detriment, okay? And that was the biggest issue. It wasn't replaced, which would be more sensible or practical, or what would be recommended by the authority, which is the vendor with the license. Was there another question? Yes. Oh, she said that the roof is on its last leg. Have any of you ever had properties like that? Well, the problem with that is it comes down to pure negotiation. Is the roof functioning? Yes. The assessment by the inspector may be, or the roofer may be, that we have about 5 years left on the roof. Or we might have, 2 years left. Sometimes they're very specific. I know my roofer was. It's kind of like they have a stopwatch upstairs on the, shingles, and they looked at it and said, okay, well, you have to pay $15,000 for a new roof in the year 2014. So what happens on this is exactly right. The seller looks at it like, hey, that roof is doing just fine. We don't have any leaks. It's not in need of repair. And I'm not going to negotiate for it. And the buyer goes, Well, the seller better do that because they're now going to have to disclose that condition to the next buyer, and I want them to replace it. It comes down to the parties have to decide. You don't get to say to the listing agent, well, y'all understand you need to do this. Well, that never works in posturing. It's truly what a buyer and seller want to facilitate. And the seller's made a clear signal already that they're not going to do it. That doesn't mean that upon further evaluation or request for a claims adjuster to come out and determine the condition of the roof. Lots of things happen, but basically if a seller says, I'm not going to do it, can you make the seller do it? No, you can't. Even the listing agents, even the wife of that seller can't make them do that. Or the husband can't make the wife do it. You just want them, it is really negotiated. Does it make sense for a buyer to say, I'm going to go forward, and then come back and blame you a year later when they have to repair the roof and they found out that the wood decking under the roof was totally rotted? No. See, that's the problem, is they think that, oh, I'll go forward with this, and their agent has lacked clearly stating that you do understand that you're going to have to replace this roof in the very near future. I understand you want to go forward because you really want this house, but I just want you to be prepared for that because that's a big expense. Have any of you replaced roofs? It's outrageous. Yeah. Okay. Now, paragraph 3 of the amendment, it says the date in paragraph 9 of the contract is changed to, okay? In the contract it says on or before, and it says a date. The rest of that paragraph is still very important. It says that the non-defaulting party has remedies under this contract, and look to paragraph 15, default, okay? It still says that they have to close on that date. Doesn't say that they get an allowance because the lender didn't have the docs there, or I didn't get my IRS return certified, this type of thing. It is a drop-dead performance statement, and we should all be looking at it. It's not that the buyer and seller can't negotiate the change. We've got it right here. It's a paragraph 3 to amend paragraph 9. But in light of there being no amendment to extend that closing date, buyers often send it and they think it's done. And until a seller agrees and signs and this becomes an executed amendment, it's not added to the contract. Doesn't replace what's in paragraph 9. Paragraph 4. The amount in paragraph 12A 1B of the contract is changed to. This is not an added to field, it is a change to. So if you negotiated taking the seller's equity from them as a buyer's, and you said, I want $6,000 of the seller's equity to pay for my closing cost, and now you want to change that value of $6,000 that was agreed in the executed contract, you're either going to add to the $6,000 or you could take away from the $6,000. Okay? So $6,000 is a lot. So let's go in and say originally the buyer negotiated $1,000 from the seller, okay, for their closing cost. And now because of the condition of the property and their buyer agent has postured it very well for the buyer. Look, these items, do you feel real comfortable with the seller choosing the vendor of their own choice and making these repairs and then you having to re-inspect it and agree to acceptance prior to going to closing and funding? Or would you like the seller to pay more of your closing cost? You keep the money you were going to put on the table for the closing cost in your pocket, and you can facilitate these repairs the day after you move in. That's your script. Because then the buyer is going to say, you know what? If they give me $2,000 more, I'll take that. So now instead of the $1,500 we had in the contract, what's going to be in paragraph 4? If he wants $2,000 more, you're going to have $3,500. You see the difference? Be very careful about that. There have been agents that they negotiated $500 for repairs and they added $500 there, and it took away the $6,000 that was in the contract. And yeah, and the agent is the only one who made that mistake, and so it took $5,500 away from their commission. Well, sure. That's negligence and incompetence. Even I know that.
Don't you think that according to ethics, the other agent might say, well,
Let me tell you, that is how I work.
Yeah.
I would say, you know what? We agreed to $500, but unfortunately in the contract you negotiated $6,000, so now we need to put $6,500. You don't have to say, and oh, by the way, do you know that the buyer can have $6,500 from the seller? No, that's not what we say. That may be what you've told the seller. Say, you know what? This buyer agent hasn't disclosed any of this, but I talked to the lender, and the lender said under their program they can ask this much max from the seller. That's a buyer's agent's job and a buyer. So be careful. Don't negotiate something that you don't have in writing from the lender saying that this buyer can ask the seller up to this percentage of the sales price for closing costs. You have to have that in your arsenal in writing from the lender. Because this is seller's money in paragraph 12. This is not buyer's money. This is seller's money. Okay? And if the seller said, I'll give you $6,500 in closing costs, and the buyer only has $4,500 in closing costs, where's the $2,000 go? Seller's pocket. It stays in the seller's pocket. Most of the time the other agent says, no, that seller needs to give us a check out at closing for $2,000. Do you do anything out of closing? No. Is everything on the HUD 1? Yes. Always? Absolutely. It is fraud otherwise. I don't care if it has to go back through underwriting and the HUD has to be approved, but I don't care. It's not about that. What it is truly about is that you do not participate or facilitate anything that happens that's not on the HUD 1. We have an issue right now between two Keller Williams offices. And what they did was the buyer says, but I don't want to delay closing. Y'all just give it to me outside of closing. And now one of the agents called me and said, can I do that? I said, not without your broker's permission, and they're never going to get my permission to do that. So we had to go back to the other broker that had already done it. And I said, since you've already violated it, how about we give your office the money and then you do with what you want? But that other agent's not going down. The agent that already gave it to him outside the HUD 1, they're going down if anything happens. They've already done it. We can't stop that. Yes?
Marilyn, how are you running, because I'm helping my sister purchase a house now, and I want to contribute part of my commission to her closing. Where exactly do you put that?
That would be in paragraph 9.
Paragraph.
Yeah, we'll get to that in just a minute. Yeah. Paragraph 5. The cost of lender-required repairs and treatments as itemized on the attached list. Where does that list come from? The lender. The lender-required repairs must come from the lender. Okay? The attached list from the lender will be paid as follows. It's fully negotiated. The contract states that no party has to do them all. They don't have to do any or all. And in this instance, the paragraph says the buyer will pay this much and the seller will pay this much. How many of you have been seeing lender-required repairs lately? It's rare, but I've seen it come back since February. We have seen more lender-required repairs than I did the previous 3 years. The lender-required repairs? When an appraiser goes out to the property for the lender, because that appraisal is for the benefit of the lender and the person who's going to be absorbing that debt, not the borrower, that lender says, look, I'm going to appraise this, but the following items must be done. And it comes from that appraiser's report that it is the lender required. Most of the time the lender presents it to the buyer agent in a list form that says the following things need to be done. The roof needs to be replaced, the water heater, plumbing, all sorts of things. Whatever they find as an appraiser that says, I cannot give you the value on this unless these repairs are fully done prior to closing and funding. Yes, Phil?
I had a buyer, we
Oh, yes, the lender gets a copy of this amendment, so the lender knows exactly what the parties have negotiated, either as far as condition of property in paragraph 2 or in these lender required. Yes, they get a copy of these amendments, so they absolutely know what's going on.
Whether the appraiser picks up that or not, because I put it in an amendment, I get documentation to give to the lender.
Oh, yeah, the lender gets anything that has to do with the contract, because the underwriter has to see that. And sometimes that's stopped it when it's on an amendment. That's why negotiating in paragraph 12 to have more closing cost or offer the sales price does not disclose the true condition of the property that one party may want. Maybe not required, but one party may want. Yes?
Well, and if you change paragraph 12, jump back to it from the lender, that it does involve the percentage, because you may get all the way to closing, and there'll be a $7.50 over allowance to the buyer, and they can't close.
We just discussed that. That is a requirement for a buyer's agent to have it from the lender in writing. What is the max that a buyer can get? Okay? And if the buyer is required to have concessions from a seller in order to buy this property, you have even more concerns as a buyer's agent to make sure that that is done and well within it. Yes?
I just had this kind of VA law, where the repairs were rolled back into the closing costs, and actually, the buyer was getting back more than their closing costs, and the title company gave them the difference. I mean, it was like less than $1.
Her operative word was VA.
So that's different than FHA.
Yes, yes it is. VA, they legislated years ago to say to our veterans, we will do this for you. And so the veterans have an unusual program, a Texas vet in particular. How many of you are aware of Texas vets benefits? Oh my word, it's phenomenal. In my part of the world, we have a lot of retired military. And so we were very familiar with that. It's wonderful. USDA is another one, the new one that's added on a third-party financing addendum that we'll talk about. USDA allows a lot to be done for that borrower and buyer that are not done in a conventional program. FHA is real purposeful about the buyer not getting any money because of all the issues that happened regarding those. But veterans, no. Veterans are provided a wonderful opportunity that doesn't fit into our traditional molds of conventional financing in FHA terms. Paragraph 6. Buyer has paid seller an additional option fee of, and there's a $sign. Now we've been told by Trek and our attorneys that an option does not exist without money. You know how our contracts can have no earnest money? Options cannot. The definition of an option is exactly that one party has paid money to the other for that option. So it can never be zero. And now the attorneys are coming out in light of a lot of people putting $1 down. That was going on for about 5 years. You saw $1, $10. One attorney raised their hand and said, you know what? I'm going to file suit because I don't think that there a true option existed because of the dollar amount being $1. So, you know, lawyers can take it and interpret it and do all these things. What we have been told is that if the buyer and seller negotiate in paragraph 23 of the contract a per diem type of charge, that same per diem type of charge will reflect on this amendment for an additional option extension. So just keep that in mind. What the parties agree to is fine. Again, some attorneys want to make a big issue over it. If the parties agree to it, that might be okay. But in the event that an attorney representing one of them is going to contest that there was never an extended option because $1 is not consideration for it, then you could have your problems. Yes?
Where do you get that additional option money if you did?
Where do you? The buyer agent will take it to the listing agent. You can do that on page 9 if you want, or you can just put a receipt in a receipt and say I've receipted additional option fee and hand it to them.
Does it have
it has to be there immediately. No 3 days. It's immediate, okay? Because again, the buyer and the seller's performance is critical. The seller doesn't have to extend it if they don't have it in hand, receipted, and the buyer won't have it if they don't have it receipted immediately. Same thing with any additional earnest money, same kind of thing. And again, earnest money is usually receipted at a title company, right? They have business hours, don't they? Gosh, I love that, business hours. We don't. We have some customary operation hours for the brokerage operation, but for the most part, the realtor is going to have to get together and make sure it's expedited quickly. Besides paying an additional option fee for an extension of the unrestricted right to terminate the contract on or before. In paragraph 23, it is a number of days, but in this amendment, it says this consideration of additional option fee is for an option extension until this date. So it has to be an actual date. So again, make sure you don't put a number of days in there, but there's an actual date in there. The last paragraph is asking, okay, now we covered in paragraph 23 if this option fee will or will not be credited to the buyer at closing, right? Okay. And now it says the additional option fee will or will not be credited to the sales price. So they take care of that same issue of being credited for the additional option fee. When you as a listing agent receive the option check, what do you tell your sellers to do with it? Immediately. Sometimes we found out that it bounced in the option period. Not good for the buyer. Okay, so that's why it should be timely that it's done by your sellers, because in the event it does bounce, the buyer does not have the unrestricted right to terminate. They've actually in default of that paragraph. It doesn't apply to them because the option fee check bounced. Okay. The other thing is we've had several instances where buyers are getting ready to close, but the sellers have already moved on. They were a corporate relocation and the company packed them all up and moved them. And then the sellers have a mail out. So the buyers have already signed and taken care of this. This mail out goes to the seller and the seller goes, why am I giving this credit of $300 to the buyer? And the listing agent says, that's the option fee in paragraph 23 that you agreed to credit to the buyer at closing. They said, I never cashed that check. I don't know where it is. I'm not giving it back. That's not an excuse for the seller. They will be in default of the contract if they don't close. So that's why I know listing agents aren't doing a very good job. They're not telling them you need to go to your bank today and cash this, because you will have to give it back to this buyer when they close and fund. Okay, so I know that that's not being done. Yes, ma'am. Okay. Oh, well, I'm gonna share this. She says, would you like to tell them about the seller that washed the option check? And in his shorts, they were laundering an option fee check. Not money, but the check itself. So what happens is the seller demanded that he be given another check. Does the buyer have to do that? No. Oh, but you know how they demand. Well, what it turns out is that the fee to cancel that first check, because the seller washed it in their pocket, well, there was a fee. Who's going to pay that fee? Oh, no. The seller said the listing agent, because the listing agent, blah, blah, blah. So again, you notice how they manipulate this. The best way for you is when you have that option fee in your possession, you've receipted it for your seller, and then you've delivered it to him. You followed up in an email. As I told you, you better cash that. Do not put it in your pocket or a box. Do not wash it. You tell them the same thing and tell them, because you don't have the ability to come back on the buyer and ask them to give you a new one. We had one that really mutilated it, pieced it all back together, and took it to Frost Bank and said, can I cash this? What do you think Frost Bank's, yeah, no. No. So again, I think that's really what happens is that, you know how when you live in a world of saying it's what I interpret it to be, not what we know it to be, that's because somebody has not literally explained it to them and then put it in writing. For some of us, we're auditory learners, right? You can sit in a room and listen to me talk, God love you, and absorb. Others are learners that if they read it, they place it in a part of their brain where they can recall it. So, you know, we're all different kinds of learners. Do you know what kind of learner you are? Are you an auditory or do you read it?
Read it.
Read it. And you know, once you know what kind of a learner you are, it helps you tremendously to retain information. And many times, sellers will say to us, well, the agent never said that. And I know the agent said it because I know that agent. You know, so in writing, it's so much better for us because when one party says they didn't do this, we can say, oh, but they did. Okay. So again, it's not always about us saying to the other party, here, I'm going to put it and rub your nose in it. But many times it helps us get them off of the dispute of blaming you. And we had one seller recently who was on their high horse. They were blaming the agent. A horrible thing. The broker was being sent these horrible emails, all this stuff going on. What do you think the seller found out? They were wrong. And they had to apologize. And I got to read the apology. And that's rare. But this person had caused a major scene. They called and were horrible to the receptionist who answers our phones. They were horrible to everybody on the team. They were horrible. And they were for no reason. So sometimes people get into these emotions and they think, I'm going to do this until everybody is, you know, slayed. So again, just make sure whatever you say that's real significant in verbally to your client that you followed up in an email, okay? Uh-huh.
From our office, we send like a congratulations email and a contract. It's pretty much a standard form email to our clients. And then we tell them the next step and then this is optional, positive, blah, 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 blah. Is that sufficient enough to cover our clients?
Yeah, she says that she has a standard format. Congratulations on your contract. This is what's up next. My time limits is perfect because it takes all of the dates and puts the actual performance dates for it so you can attach that. They can see it, review it. Once you have proof that you delivered it to them, that is an arsenal. Now, if you have clients that don't read and don't answer their emails, chances are you're going to have to probably deliver it to them, either when you're visiting with them or doing something. And so make sure they sign off on it if you hand deliver it, okay? And this happens sometimes. Most of the time, we've got people who communicate by email. And so they're used to using it. But we had one where a seller had 5 emails and gave instructions in the listing agreement that the listing agent could only use 1 email to communicate. The seller sent an email to the listing agent. But do you think they used the 1 email that they could communicate with? No. So this listing agent had to constantly respond, not to reply, but respond with only the email they were given authority to communicate to the seller. So be careful. If you have clients like that, they kind of hold you to what they put in writing as an instruction to you. And our first inclination is to reply, isn't it? It would be mine. If you asked me, said, Marilyn, reply to another email, well, you might not get it timely because it won't be as easy for me to just say reply, okay? But be careful about that. But that's always very good to have a statement of state of address once you have an executed contract saying this is what you need to do. Paragraph 7. This is a wonderful little paragraph. And good listing agents look for this when an amendment is presented during the option period. And it says, buyer waives the unrestricted right to terminate the contract for which the option fee was paid. Okay? So what happens sometimes is buyers say, I'm going to negotiate with the seller. I still have 5 more days on my option, but I'm going to go negotiate with the seller. Now we've got an executed amendment. But the buyer will not waive their unrestricted right. Are y'all following me? Okay, so as a listing agent, you better pay attention, because here's what happened next. The seller went and did all those repairs on that checklist. They had agreed to it, 5 more days on the option. They did all those repairs. What do you think the buyer did on the last day of the option? They terminated. And the seller came after the listing agent and broker. Said, why on earth did we not counter that they waived it at that point? Why didn't we do that? Why didn't you tell me that's what I should put as a counter back to the buyer? Instead, they went and made all those repairs, and then the buyer had the unrestricted right to terminate. Well, the seller wanted to hire an attorney and not give back the earnest money because they felt that was not fair, that he had negotiated with them, and yet they still had the right to terminate. So it fell on the listing agent. As a listing agent, you always want that waived. Again, the parties have to agree to it, but I think a seller would have to be told, if the buyers and sellers didn't agree to waive it, okay, that the seller would be told, you know what, let's just wait for you to move on this amendment and act on it until the option period is waived. Okay? And it's not that the seller probably still shouldn't make those repairs. They probably should. But you don't want them to say, you didn't tell me that these people could still come back and terminate even after I gave them all this concession. So be very careful about that. Paragraph 8. This is the paragraph that Trek said they got so many complaints from buyers whose buyers' agents failed to use this paragraph that Trek literally threw their hands up. They made that one of the opening statements in our risk reduction meeting. And it said, the date for buyer to give written notice to seller that buyer cannot obtain credit approval as set forth in the third-party financing condition addendum for credit approval is changed to. In that addendum, it's number of days in that first paragraph. If those number of days are passed, the addendum no longer applies for the individual. It's gone. It's not a part of the contract anymore. So prior to those number of days expiring or passing, the buyer agent and buyer will say, let's negotiate, and ask the seller to extend my ability to get individually approved and give notice in the event I'm not going to get approved. Okay? So Trek had said that, these buyer's agents need to try that provision. What's the worst thing that a seller's going to come back and do? Say no. There's no seller on earth that will extend it. And if I find a seller that would extend that, I need to know where that person is. Because there is no seller on earth that would say, oh, sure, let's extend all the contingencies I have in this contract. It just comes down to common sense. No seller is going to do that. They might feel sorry for the buyer, and some of them might say, well, okay, I'll extend it. But no listing agent will ever say, let's extend this. Do you think their listing agent would do that? No, because you know the contingencies.
What kind of remedies that can a seller try to get, or I had this situation, my buyer switched jobs, and I didn't know, and the lender does a double verification before payment, and so the contract has to go back to underwriting. I mean, when it's close to the table, it has to go back to underwriting. And we were closing early, so the contract didn't expire until about 5 days later. But at that point, we're way past the credit approval, but it has to be unwritten, it has to be on paper.
Yeah, if you pass those number of days, the buyer has no provision to receive their earnest money if they do not get individually approved.
They claim any more remedies on top of that.
Who, the seller? She was giving a scenario, and what I was able to follow is that the closing date was 5 days after people actually physically signed. Yeah. The closing date is the drop dead date in the contract. If the parties have not closed by that date and funded very soon after, the party that doesn't do that is in default. It says so in paragraph 9. Well, see, the seller had to wait until the closing date to do anything. Yeah, and a seller doesn't ever have to extend, do they? I get those calls all the time. Here's what is bad for a seller, and it's only in the court, the view, that it seems detrimental to a seller. They're very pro giving concessions to a buyer, right? Consumer protection. And so what happens is the lender drops the ball. Through no fault of this buyer has paid for all their inspections, they've done everything per the contract, the lender dropped the ball. That third party that all parties agreed in the contract to bring into this, okay, that lender dropped the ball. And the seller says, why should I have to pay for the buyer's lender's mistake? Do you agree? Yeah, I see it that way. And then the buyer, why does the buyer have to pay for the lender they chose for their mistake? It doesn't seem fair to either party, does it? No. And so what happens, and I'll tell you what, I am really tired of this. The lobbyist for the loan association is mighty powerful. Oh, they are. I've seen them, and they appear at our conferences. They're mighty powerful, folks. And yet, the only nick that they can typically take is in the event that they misquote a fee that could be construed on the good faith estimate. They don't get in trouble for dropping the ball, letting the file slip, all this. Their president or their manager will say, oh, I'm so sorry, and that's it. Some good lenders don't do this normally. That's not the way they operate. So we don't have these issues. But once in a while, mostly banks, and I say that banks not as a dirty word, but really the oversight within a banking operation and their mortgage division is very different than it would be for like a W.R. Starkey or a mortgage banker or broker. Just different. It's working within it. Well, yeah, and that's not uncommon in that mortgage division, working in the framework of a bank. And so the problem is that a lot of times the buyers are blaming everybody but where the fault really lies, the lender trying to make it right for them. And the big problem is buyers and sellers have to come to an agreement. Everything has to be agreed in writing, otherwise it doesn't happen. And if a seller says, I'm not extending it, I understand you paid all this money, we really wanted you to have our home, but I am so worried about your lender that I'm not going to extend it. I don't trust your lender. That's usually what we get, the calls from the sellers. And so sometimes the buyers go back and they say, look, tell the seller I'll go to the lender of their choice if they will extend this. I'll transfer my file. You know, a lot of times the buyers are like, they don't trust this lender either. If they drop the ball this time, what thinks that they're going to be able to reveal? So again, it has to be always agreed upon between the buyer and seller. But I have typed in something right after the date in paragraph 8. I said, always try as a buyer's agent to extend prior to the number of days in third party expiring. The worst that a seller will come back and say, no. Then you go to the buyer and you have proof, we tried, but the seller said no. What do you want to do? In the event that the number of days in third party will be tomorrow, the buyer has a choice. Per that addendum, they would give notice, written notice to terminate and get their earnest money and go away. Okay? If they go forward past the number of days, they will lose their earnest money if they're not individually approved. Not about the property, but about them individually. Now, paragraph 9, other modifications. Insert only factual statements and business details applicable to the sale. What I see most of the time is, we'll get to the no contingency warning, but most of the time I see paragraph 1 parties, buyer is amended to read as follows, and then they will place the additional buyer, or they'll remove a buyer from it. So a lot of times, again, this amendment may add something or take it away. So the lender says, we've got to remove this person from the contract, and you're good to go. You'll do an amendment. The other thing it would say, paragraph 2, exclusions. is amended to exclude the following. All of a sudden, during the option period, the sellers realize that their listing agent didn't tell them to read paragraph 2, and they found out that these certain things are going to be attached to the real property, and they convey to the buyer in the contract. The seller gets upset. They negotiate. And so that is a way to remove that or add to it. So again, this paragraph 9 is for every other paragraph in the contract or addenda that are not listed through 1 through 8. And that's how you'll do it. You'll reference the paragraph. You'll reference the addendum. And then you'll say the change in paragraph 1 will be such and such. In other words, make it very clear what the parties are trying to modify from either a paragraph that's not mentioned in 1 through 8 or in through an addendum that has been attached to the contract. So again, it has to be very clear. No contingency language. You know, if buyer does this, then seller will do that. That's not what we're talking about. When they say factual and business statements, they mean buyer and seller agree to a final walkthrough 24 hours before closing. Those types of things. The seller's temporary residential lease is attached to the contract. Okay, so in other words, it's very factual what is being done. The other time we will see things is many times when you turn your contracts in before they close, we can actually help you. And sometimes we see where an agent has a relationship with the principal they represent, and they did not disclose it in writing in the contract. So at that point, we're going to ask them to disclose it in the amendment. So it would say, listing agent is related to seller. Buyer's agent is related to buyer. Buyer is a licensed real estate agent in the state of Texas. Code 4 of the articles. It's a violation for you to do that. And the code of ethics is pretty black and white. When they find out you have not followed what they deem as the code, they're going to do something to you. And so we really, you're laughing. It's not funny for those that sit on the other side of the table from the grievance panel that sits in these hearings, because they're scared. They've never been accused of anything like this, and their intention when they did it or lack of doing it had nothing, they didn't do it on purpose. They made a mistake, and the other party called them on it. Yes?
What if you do a co-op, my sister's an agent in Houston, what if you do a co-op with your sister from another agency? You have to disclose
Oh, absolutely. You are blood related.
that.
See,
Where would you put it, Marilyn?
in special provisions in the offer,
Okay, the buyer's agent is related to
listing agent, you bet. Oh, that's critical. In some families, it wouldn't be. You know, you just don't know. Are they a close-knit family, or are they Hatfield and McCoy's family kind of thing? So you don't know, but you must disclose that, yes. The statute says we must disclose any blood relationship, but I'm going to tell you, in my experience, you disclose any relationship. Don't get into details. Just be very simple, okay? I don't want a lot of it. What I love is if you have to disclose these details and the broker happens to be an intermediary in the transaction, they hold the license of the listing agent and the buyer's agent. And I love it because in the last paragraph for this intermediary notice, it says any business relationships. In other words, it gives you room to describe. And great listing agents say they have worked with this seller on numerous business transactions. So now the buyer, the broker's an intermediary, right? They've got an agent, but now the buyer knows, oh, this listing agent not only is the listing agent for this property, but they have a long-standing relationship with the seller. So it's not going to be a surprise to them that they're a well-oiled machine and they respond a certain way. Do you know what I'm saying? So it's really great when you can provide a factual detail like that without going into a lot of detail. Now the yes?
Question about amendments. If you have multiple amendments,
Mm-hmm.
what is the best protocol for
they are actually already done that way. There's a subsequent amendment, 1903, but nobody knows it, and it's coded down at the bottom. And again, that's for agents who have no life that know that. So what I'm going to say to you, what I'm going to say to you is that the amendment adds to it. When you said the word, did you use the word supersede?
Yeah.
Okay, that's a neat word, isn't it? Do you know what it means?
Yeah.
Okay. A lot of people might not know what it means. And what he's saying is that the parties say agreed to one previous amendment, okay? And now this amendment is going to supersede the previous amendment. In other words, that previous amendment is going to go away. I would prefer that in this subsequent amendment, which gets added to it, just like we're just piling them on, they just keep adding to the contract, that you notate what item will be eliminated from the previous amendment. Supersede is a word that defining it, somebody could misinterpret it. And I want it to be very clear. If this subsequent amendment is to remove a provision that was on the contract or in a previous amendment, let's put it very clearly so that the parties know that's no longer a part of the contract, or we've modified this part. So again, they are numbered for subsequent amendments, but make no mistake, all of them add to it. The word supersede that he mentioned comes into play a great deal when we see a relocation addendum and when we see a bank-owned properties addendum. Because what they do in those addendums, they take out most of the provisions in our contracts that give consumers and buyers options.
So we have multiple amendments on a contract, that each one does something different than the first one.
You're fine.
I'm fine.
You're fine.
I don't have to number them.
No, no. I would like to see them. Do you think that'd be kind of nice? I love all the contracts that have no amendments that I know are not real. You know, your broker needs all the copies of the amendments, okay? Yes?
If we send our book to you for compliance and it passes, and subsequent to that there's an amendment, do we resubmit it to you for compliance?
Absolutely, because many times that amendment could change sales price or some term that we keep in the Mark has in his accounting system for us. And you're absolutely right. You will submit it for review, and then we send it on to the MCA, letting them know that the contract's been amended. Matt, any other questions? Yes, ma'am.
I apologize, but I think it's more back on 8. We had an experience yesterday where Friday we were representing the buyer and we were going to closing, and the lender said, "We're good to go, everything's great." Monday, when we get to closing, the lender says, "Oh, no, we're not good to go," and change the terms of the buyers down, closing costs and so forth.
Mm-hmm.
What would be your recommendation on, as a buyer agent, should we communicate to the buyer in the third-party financing with date, whatever that timeline is? So let's say you've got 21 days. Mrs. Jones, we need something from your lender that says you're approved, you've met this, just to have in our arsenal.
Can we do that when we talked about the addendum? Because we're going to talk about that one next. Okay, just remember that. No contingency language, just clear facts. Remember that if you see something, if you are presented an amendment from the other party and you get it and you look at it and you think, I don't know what this means, or what are they asking the seller, that's going to be the same thing that's going to be very difficult for your seller to understand. If you don't understand it, please, you can always call and ask for verification, or talk to your seller and say, you know what, I can't interpret what they wrote. See, I'm not a lawyer, neither are you. In the event you want to consider this, I recommend that you get legal counsel to help you with this, because I've never seen this, and I know that this is something that you better be careful of in the event that you say it's okay. Because a lot of times You're digitally asking them to come in and sign these amendments. Okay? You're not in front of them. They don't read. They sign. And then you said, oh, I just got it back that you signed it, but did you talk to an attorney about this? I mean, I told you I was really worried about this. And they said, no, I just went in there and signed it. Okay. That's difficult for you because the steps that you take before a party signs and acknowledges, traditionally you're in front of them. You're explaining it. You have a conversation. And when we go to this electronic signature format, this platform, it takes away a lot of your certainty. Did they understand what I wrote in that email? Did they even read that email that I wrote to this? That kind of thing. So you have to be very careful about something like that. Yes?
Do we have a list of bona fide real estate attorneys so they don't just go out there with some guy?
I have several attorneys that have done E&O work for this operation or other operations. They typically find a family member or friend that's an attorney that's not a real estate attorney, and you really need somebody very proficient in the real estate contract. So a lot of times I give the recommendations for the attorneys that I've worked with that are around here that are friends of Keller Williams. You always want me to know if you're working with your buyer or your seller has an attorney. You might just listen to that name real well and then ask me. We've had several of them sue Keller Williams, and I told the agent, you'll be next. You either terminate or get out now. Because we know some that are coming after us. And so they've made it a kind of a passion, and I don't want you to get caught doing something without knowing that. Yes, sir.
So I send my amendment, two of them or three of them the last time, they sign them, they forget the date, and send them back.
Okay. Philip, you're saying that you received an amendment signed,
Correct.
but the other agent who had it last did not execute it.
He was supposed to.
I don't care who was supposed to. You found out. The moment you found out, you would contact the other agent and say, I'm placing the executed date of today.
Okay.
There you go. You can't let it go. You have to be active, proactive. You cannot say, oh, I'll take care of that in a couple of days. That's not how it works, folks. There are time limits in these performance, so you must bring it to the attention. The problem that we've had in the past is that we knew it as an agent. We saw that it wasn't executed, and he said, oh, I'll take care of that. That's the wrong date. We didn't all agree to it. My seller still had to counter it, and the other agent already executed it and was a real counter back to the seller. And the listing agent didn't put the stop sign up and say, no, you countered back to my seller. There is no executed date. And the seller came after the listing agent. And the listing agent's job is the moment they see it, they have to tell the other party there is no executed date. This was a counter to the seller. I am blocking this out, and as soon as I have the seller agreeing to this, then I will execute it and tell you that we've got an accepted contract. And the agent didn't do that, and they let it lapse for a few days, and it became a major problem. And the seller came after the listing agent. So don't let somebody else's oversight go. You got to take care of that right away. Now, we have an attorney who used to represent other brokers in Keller Williams because there are operations, attorney firms that say to an E&O insurance provider, look, I'll do all your claim work at a greatly reduced rate. So what are they working on? Volume. They're like us, right? They're lead generating, and so they work on volume. And all of a sudden, I saw this attorney's name who used to defend realtors and brokers, all of a sudden on the plaintiff's side. And I told our attorney, I said, well, when did he cross over? This is not like them. Sure enough, when we sent it in to our claims adjuster, the claims adjuster, and I put it in the notation. I said, Ruben used to represent brokers and agents, and now he's suing them. And the claim adjuster found it, and of course he has the national account for this big company, and he sent an email off to these two attorneys and said, oh, so now you're suing Keller Williams? Oh, no, we're not going to sue them. So they're no longer going to be able to represent that plaintiff. See, you cannot cross some lines. And we have to do a much better job as agents to kind of keep your antenna up and your hearing. Listen to what's saying. You don't have to contribute, just listen, and then you come back and find out if they've ever sued us or gone after us. A lot of the things we've bypassed because we knew that information going in. We had a little leverage on that. Okay, now flip it over.
Wait, Marilyn's doing this, there was somebody that asked a question about credit for
Yeah, I want to contribute part of my
Right,
commission.
you have to put it here in paragraph 9.
Now, does that affect anything, do I need to ask the lender, will that affect?
Well, you should have known that ahead of time, as if you represent it. Yeah.
I asked, but since it's USAA, they're very difficult at getting back and forth, they're
Yeah.
not answering my questions.
Well, the problem will be for you is if you put it in writing, all the parties, you can give anything to the principal in the transaction, but you have to have it in writing acknowledged by all parties. Okay? The problem for you would be is if y'all had executed an amendment to reflect that you were going to give a concession to your sister's closing cost, and the lender saw that and they said, no, you can't do that. You can't do it. Okay? So once a lender says no, that means what? No. It doesn't mean you're going to facilitate another way to get behind it. In this instance that she gave, she talked about her sister, right? She's representing her sister and she wants to give her sister a concession of her commission towards her closing cost. So here's what happens, and this is very touchy because they're related, right? The lender says no. God bless you. Her sister, who's an agent, says don't worry about it. What does don't worry about it mean? Can she take care of it later? Absolutely not. Now she can take them on a nice vacation if she wants, or she can buy a housewarming present, but she is not giving them a cent that wasn't on the HUD-1 agreed by all parties. And that's the hard part. You know, when you're related, you think, oh, well, we can do this. No, we can't. You can't do that, ever. And my concern for you is I've got these things in emails that show that you violated something. See, that's the problem, is you've removed all doubt now. We know exactly who we can nail. And that's how they look, these entities that want to come after us, called the government. Okay, now we're going to go. Flip it over. Now, what's the first addendum? Third party, financing addendum for credit approval, right? Okay, everybody there? Because now we're going to go really fast. Okay. At the very top, I typed in, this is for individual approval only, not the property. Now, it's true that Trek put a note under the first paragraph saying that, but I'm going to tell you again. I'm going to tell you over and over and over and over until you master. You're in the mastery here. This addendum is only for the buyer to say to a seller, these number of days in this first paragraph are going to soon pass. I am terminating pursuant to this addendum not being approved. Okay, and that's how a buyer does it. And the notice of buyer's termination has a little box for that. What is interesting is Betty made a comment. She said, if I remember this, she said, shouldn't the buyer get something from the lender saying that they're not approved? That's what you were saying. Did you notice what I just said? Should the buyer get something from the lender showing and proving that they're not approved? Do you know when final approval occurs for the individual? Sometimes they're really doing it that morning when they're supposed to close at noon. Yeah. Okay. So there is no proof. Trek has reiterated. The buyer doesn't have to prove anything. You're taking the buyer at the word. This is a buyer, a major contingency for this buyer. It says, hey, Mr. Seller, if I call the lender up and I've given all this information that I'm required to in this paragraph, and I call the lender on the 19th day when I have 20 days in here, and on the 19th day I ask the lender, am I approved? And the lender goes, no. You're pre-approved, but you're not approved. The buyer says, I'm going to provide notice to the seller. I'm terminating pursuant to this addendum and getting my earnest money back. No ifs, ands, or buts. There is no proof. If it said you had to have proof, Trek would have put it in the form. They don't put it in there. And that's because the lender, being asked on the 19th day, they haven't even touched the file yet. And I know this because I'm a realtor. They haven't even touched the file, and they're saying to the buyer, of course you're not approved. We don't have approval on you. So the buyer goes, okay, I'm terminating. And the seller has waited 19 days, planning their life, thinking they're going to have a contract that is going to close and fund, and this buyer is negotiating. So there's a little fill in the blank. This is a fill in the blank class, right? Okay. Never leave it blank. You can highlight what I wrote in that margin. Never leave blank. You know, blanks are deadly. Blanks are not zero. Is 0 a value? Yeah. Is it got a lot of value? It has nil. But it's 0. It's not blank. A blank could be construed as 0 or infinity. That's per the Trek attorneys. And you don't want to get caught in a court battle trying to define a blank. Your job is to what? Fill in the blanks. So as a buyer's agent, I'm wearing a buyer's agent cap right now. How many days am I going to put in that first paragraph? A lot. I'm not going to go past the closing date, but I'm really going to put as many days as I can in there, because you know what? I know the listing agent doesn't read, and maybe they won't catch it. Okay, so it's strategy, and it works. I proved it. Okay, so what happens is those days are in there. Now, there's something in bold right at the end of this paragraph, and that's what you have to highlight for your buyer when you're visiting with them and explaining all these documents they're going to sign. It says, if buyer does not give such notice within the time required, and it's those number of days, okay, or it could be amended in paragraph 8, remember, in the amendment, okay, within those number of days, if buyer does not give such notice, this contract will no longer be subject to credit approval. So what happens is, while you may have had this attached to the contract, it disappears. It doesn't apply. And so we've passed those number of days, and the buyer's agent has attended this class, and so they're going back and they're going to issue an amendment, and they're going to try and extend to a date. Can they do that? No, because it disappeared. After those number of days, it's gone. It doesn't apply. And I cannot tell you how many times I see that. And that's a misuse of the form. This form is, okay, the important part for you to remember is that it is strict adherence. In other words, time is of the essence. Very few places in our contract doesn't have it at all, but in the addendums, you'll see time is of the essence. It'll come in and it say, this is very important, okay? So we do have it in paragraph 23 of the option. It's time is of the essence, yes?
You mentioned 0 versus a blank, and I hate blanks as well, but just don't like put a 0, but you just for areas where you really want to make sure it's 0, but it's just one.
You can type in the word zero, Z-E-R-O.
Will allow that?
Sure, it'll let you put letters, numbers in there. A lot of times you just press the space bar, and then you do that. It'll let you do that. Okay. Now the note that is put here is to reiterate what I said before. This is for the individual only. It has nothing to do with the property. Nothing. Now, an FHA borrower and a VA borrower have a little additional language that talk about appraisal. Even though we're talking about individual approval, they put additionally that FHA borrowers and VA borrowers are not subject to the same appraisal issues that conventional borrowers might be, okay? So there's always a provision for them. Now, it says, note, credit approval does not include approval of lender's underwriting requirements for the property as specified in paragraph 4A1 of the contract. Highlight, this is important to understand. This is for individual only, has nothing to do with the property. There may be notations about certain borrowers under FHA and VA that have additional issues regarding appraisal. In other words, VA and FHA say we never force a buyer to pay over appraised value. Okay, that's what they're saying. They just want you to know they don't ever force their borrowers to do that. Now, there are several boxes because of the paragraphs that were added. So we've got A, which is conventional financing. Make sure that there are no blanks in this paragraph. If you check box A, it's going to be for conventional. Okay? Don't leave anything blank. The first section is really for the primary loan, and the second section is for secondary in case they stack them. Don't leave those terms blank, and I'm going to tell you why. Most buyers don't know this, but if they put terms, listing agents know it, if a buyer puts a term in there that you know is not what is posted by Debbie or that you've seen online, and this borrower finds out prior to the number of days expiring in the first paragraph, they ask the lender, can I still get this 30-year mortgage for this amount of percentage per year and with the good faith estimate for the origination charges? Can those terms still be given to me today? And if the lender says to this borrower, no, that borrower, that buyer has the right to terminate as well. So you notice it was individual approval, but it's also whatever you completed as the terms. So if that buyer cannot get these same terms, they can still terminate because they can't get those terms. Okay, and it's pretty easily verified because the listing agent usually goes into a rocket mode and implodes, and so they contact the lender and said, did those terms change? And sometimes we found out the lender said, no, I can still get that borrower that. They're just deciding to, that's what they want. So that there is ways for you to verify this, not so much the other, but you can independently verify it, and it'll cause a little concern if you find out something opposite from what the representative of the buyer is communicating to you. Now, I am going to tell you that as a listing agent, when you get this third party, do you not look at those terms? Yeah, and because you're concerned too. If they put a term in there at 3 1/8, are you going to be a little concerned? Yeah. So you would never have your seller acknowledge that. Your seller could counter it, but they're not going to go hook, line, and sinker, let's give them a free out. Okay, because that would be a free out, definitely. The Texas Veterans Loan, there is one paragraph on B. C is FHA insured financing, and this is where the language we first see introduced about appraisal. In other words, it's saying that a section blank, every FHA loan has a section number. Normally we see what? 203B, but there are others. And so you have to verify from the lender what program is the FHA borrower using. And it goes in that blank. And it says an insured loan of not less than this amount for so many years, not to exceed this percentage per annum for the first so many years, and the loan not to exceed blank percentage of the loan for the origination charges. Now, there's another blank in this paragraph. And it says that as required by HUD FHA, if FHA evaluation is unknown, it is expressly agreed that notwithstanding any other provision in the contract, the purchaser or buyer should not be obligated to complete the purchase of the property described herein or to incur any penalty by forfeiture of earnest money deposits or otherwise, unless the purchaser or buyer has been given in accordance with HUD and FHA or VA requirements a written statement issued by the Federal Housing Commissioner, Department of Veteran Affairs, or a direct endorsement lender setting forth the appraised value of the property not less than. Do not leave that blank. And what field already on the contract can you point to that should be there? Sales price. Paragraph C.
Now,
3C.
Marilyn, why do they also then, a couple of days before closing, many times the lender has you fill out the FHA form or FHA addendum that says if it is not appraised, even though it's all, well, I guess because
It's the amendatory clause. It's required by the government that all parties sign that, because what they're saying now is you are swearing by your signature and the agent's signatures on this form that nothing is outside of closing and that nothing is happening that is not allowed. Okay?
Oh, because that one normally says if it has not appraised. I guess
Correct.
because this is probably already expired.
Right.
They're saying
Yeah, no,
the other
they
one-
have to have that attached to the loan package. That's part of the federal government requirements, yes.
I get several times written in special provisions that the buyer has the right to change the terms of this at no additional cost or delay to the seller.
Okay, you said, in special provisions in the paragraph 11 of the contract, that it says, buyer has the option to change lender at no additional penalty to seller or lender or terms, okay? Have you ever seen any of that?
I get it all the time.
Okay, well, here's what happens. We have been told that we don't predict the future. We don't guarantee, right? So what happens when they write language like that? They're trying to say, okay, this is what I might do, so I'm going to get your permission even if I don't do it ahead of time. Well, I'm going to tell you that if it's not applicable right now, I would never have a seller agree to that. That's right, because a seller needs to know, is this an issue that the buyer is coming to me for agreement? I'm not going to give a blanket statement that I agree to, because something might have happened that a seller, given the opportunity, might not have agreed to something. Now, is there a lender named on this addendum? No. Is there a lender named in the contract? No. It doesn't stop this borrower/buyer from going to anybody. It doesn't stop them. It doesn't stop them. There's nothing in the contract or addendum that stops them. What could stop them is a big brick wall called closing date. The buyer will be in default if they don't close on that date. So that's the big brick wall. It certainly isn't because the lender can only be this lender. That buyer has the option to change their lenders anytime they want. The problem for the buyer would be is if they don't what? Close on that closing date, then that could be problems.
If they want to change the terms.
Could be. Yeah, you can change the terms with an amendment. You can do that. Yes.
So if they fill out this amendment and push that,
The addendum?
the addendum, and says that they want this price at this rate on this date, which was what they originally agreed to with the first lender, but then they change to another lender that will not meet those same requirements, can they still back out of the contract?
No, they cannot. She asked a very good question. They're with the first lender that the buyer chose, and that first lender gave them the terms, and those terms were filled in these blanks. And then they decided to switch lenders, but that second lender can't give them these same terms. They give other terms. Can they then terminate? Well, it says in here, you get to terminate prior to the number of days expiring if you don't get these terms and they're not tied to a lender. Okay? It doesn't say lender A or lender B. It says these terms. The problem for that borrower is usually they're past those number of days and this has disappeared. So in the event that they go to another lender, those same terms would be what the buyer may say, I'm not getting these terms. I'm going to terminate within those number of days pursuant to this addendum. Okay? That you have to be real careful. Buyers don't count very well, so they think they can do anything they want. And those number of days in this addendum in that paragraph is what dictate that. Yeah, and you can change lenders. You can always change terms. I'm going to tell you, most of the times when people have a lot of assets, they may negotiate with the seller one way, and then they go to their lender a few days before closing and say, I'm going to put this much more money down. I'm going to change these terms. It happens all the time, and they close. The problem for you is that it has to happen for notice to be given if the buyer chooses to terminate. It has to be given within these number of days. Otherwise, lots of things go on and we don't even know about it, right? This is an addendum, a contingency for the buyer for individual approval and the terms of their loan. Yes, ma'am.
If the number of days passes, and everything's looking good, but then the appraisal happens and it doesn't appraise and the lender won't lend because it doesn't appraise.
Yeah. She says the number of days have passed in third party and the lender does the appraisal and it doesn't appraise. That's paragraph 4A1. That's the property. That's not the purchaser. Okay, so they're two different things, two different paragraphs. Okay, the second page talks about VA guaranteed financing. And they have paragraphs that talk about the same things we just read. They don't have another fill in the blank, but they talk about it. And somebody brought up how a VA gets lots of considerations, a veteran who is borrowing. So they're very protected. So a seller needs to understand that too if they accept these provisions. The new paragraph is, again, paragraph E for USDA. Have any of you ever done USDA loans? Okay. We have in our part of the world, and they're an incredible loan program. So I'm going to tell you, you need to find out and get into a seminar or something where somebody is talking about USDA and find out about that. It's very, it's highly restricted, but you need to at least know about that in the event that that might be an option for your borrower. As I said, they're very considerate to their borrowers. Now, right above the signature lines, there's a little tiny paragraph, and it says, buyer hereby authorizes any lender to furnish to the seller or buyer or their representatives information relating only to the status of credit approval of buyer. So what's interesting is we've always been given authorization. Even TAR, we caught TAR, another risk manager and I did, and TAR is telling something that's not true. And what it means is the buyer is giving authority. Now, does that mean the lender has to do it? No. That's the downside. The buyer gave you permission, but the lender doesn't have to do it. The lender's not compelled to do it, so I just want you to be aware of that. This is the most used addendum that we ever have to the contract, okay? Again, you need to understand it totally so that you can communicate to your buyer that you represent, and a seller needs to understand this is the largest contingency that we see on all contracts, okay? So again, you're going to pay attention to paragraph 1 big time. That's going to be on everybody's list. Now, the next one is the mandatory membership in a property owners association. Everybody got that? Okay. The law changed in 2012. Actually, Governor Perry signed it in June of 2011, and it became effective January 1st, 2012. When they did that, they allowed a purchaser of a property that's in a mandatory membership in a property owners association to actually get the subdivision information, which includes the resale certificate. So it's a big, huge, major change in the law, because until that time, who had to do it? Seller. Okay. It's still seller in condominiums. Everybody understand that? It's hard-coded into the contract because the condominium is regulated by a different set of laws. Okay? So again, condominiums are different than residential resale. Now, one of these paragraphs actually does not give the buyer the ability to say to the seller, there is something that I have found in the subdivision information, including the resale certificate, and I'm going to terminate pursuant to this addendum. Which paragraph is it? 4. If another listing agent uploads that in their listing packet, I am going to implode. I'm writing you down in a little black book. So I've got you. And I pray to God you never get caught. You're putting a contract addendum in a listing package folder is a violation because you're not using the proper form at the right time. I understand you being prepared like a Girl Scout. I understand that, but do not put it in your listing folder. Okay? I understand you being prepared and you want to cram it down the throat of a prospective purchaser. I get that. I get that big time. And it sickens me.
Is it like when you go on MLS, they have docs?
You got it.
They're listing
That
things that
sickens.
they say in there,
You,
that's what they want you
you got it. That sickens me. This is a contract between a seller and a buyer. Make no mistake. You don't cram it down another buyer's throat. You could be subject to big time if that buyer decides to complain. And I don't want it to be that way. I understand you having prepped your seller for negotiations in the event that a buyer presents this form and they've marked box 1, 2, or 3 under A. I understand that. What I don't get is you misusing a form at the wrong time and trying to influence negotiations. I just don't get that. Does everybody understand that I don't get that? Okay. Now, that being said, you have to mark one of these boxes. And so I've highlight that. Number 1 says, they changed the form too. They said, hey, Mr. Seller, we're going to do it the old-fashioned way, the way we've been doing it forever. I'm going to ask you to pay for it. I'm going to ask you to deliver it, and you have to deliver it within those number of days. And in the event you deliver it within those number of days, and for any reason, I get to terminate if I give you notice within 3 days after receiving it. It's a free walk. I understand how negotiations go. Number 2 says, okay, Mr. Seller, look, I'm going to do this. I'm going to get these documents within those number of days. And I'm going to pay for it. And guess what I have to do next? I have to deliver it to you. The failure of the buyer to deliver it will take them out of their provision to say, if I don't like it, I get to terminate in 3 days. See, that's a performance issue. Buyer has to deliver it to the seller, otherwise they don't have the provision to say that that paragraph was fulfilled by the buyer. Because it specifically says, buyer shall obtain, pay for, and deliver a copy to the seller. Okay? All right. Number 3. Hey, Mr. Seller, I've received all that garbage your agent sent in a PDF file. I've approved it. And now my only concern is that I really want an updated resale certificate. So there are 2 little boxes there besides that check mark for number 3. So either the buyer does or does not require an updated resale certificate. If the buyer requires an updated resale certificate, seller at buyer's expense, okay, shall deliver it to buyer within 10 days after receiving payment for the updated resale certificate from buyer. Notice that the buyer has to perform here. The buyer must give the money to the seller, then the seller has 10 days to get the updated resale certificate for the buyer. Now, buyer may, as buyer's sole remedy, terminate the contract within 3 days after the time required or prior to closing, whichever occurs first, and it will be refunded. It says before that, if buyer, due to factors beyond buyer's control, is not able to obtain the subdivision information within the, where did I say that? If buyer requires an updated certificate, seller at buyer's expense shall deliver it to buyer within 10 days after receiving payment for the updated resale certificate from buyer. Buyer may terminate this contract and the earnest money will be refunded to buyer if seller fails to deliver it within the required time. This doesn't give the buyer a provision to have a free walk. The buyer just gets to terminate it if the seller hasn't performed. Okay? Very different requirements than what you see in paragraph 1 and 2. And 4, of course, says buyer does not require delivery of the subdivision information. Now, highlight what I said. When the buyer marks this, they must be warned. They don't get to say, oh, I don't like what this restriction is, I'm going to terminate. They don't get to do that. There's no provision for them to terminate if they do 4. And the biggest thing is that the lobby for the title industry came in and said, we're sick and tired of having to get all this resale certificate and subdivision information to do our HUD-1 and pay for it. We're tired of it. We're not going to pay for it anymore. So their industry lobbyists came in and said, okay, now we're going to have a special paragraph that even if the parties mark paragraph A4, somebody's going to have to pay for it because it still has to be acquired for the HUD-1 to be drawn. Okay? So you understand there's a problem. If it's because the buyer and seller aren't negotiating because of the price, that's not true. Somebody's still going to have to pay it. And we'll get to that paragraph soon. Now, if you see the bold right after this, it says the title company or its agent is authorized to act on behalf of the parties to obtain the subdivision information only upon receipt of the required fee for the subdivision information from the party obligated to pay. Now, where this disclaimer will come into place is that paragraph I'm talking about, and it's really important because the title company has a provision that says we may not close because I can't close because you haven't given the payment so that I can get the documents to draw the HUD-1. So a lot of times they blame the title company, and that's not true. It's the party that is paying for it that failed to deliver the payment in a timely fashion. Paragraph B, now material changes. Here's what happens. The buyer negotiated for. In fact, the listing agent crammed it down the buyer's agent's throat at time of offer. You're going to use our blah, blah, blah. We're going to do for. It says if seller becomes aware of any material information or material changes in the subdivision information, seller shall promptly give notice to buyer. Here's the problem for your seller. They negotiated for, and the seller is sitting over there going, this agent's really stupid who represents me. She never asked if there were any violations of the HOA. And I am in violation, but I'm not going to tell anybody. Pardon me?
Isn't that question in the disclosure?
It is in the seller's disclosure. But the problem is, as a listing agent, you're going to verify that. You want to, in the contract for our listing agreement, it says in paragraph 12 very specifically, are you current on your HOAs? And you have to explain those two paragraphs because that's your agreement with them, and it shows that you did the right thing. You found out, they told you they were not in arrears, and they lied, or they were not in violation. So again, you have to be very careful about this. The problem...
Find that out just through the resale certificate?
They could find out through the resale certificate if there's any outstanding lawsuits. The legislation changed to do that. Or it could be that there are violations and they're not in compliance. And that's what that resale certificate states. And so all of a sudden, right before closing, we all find out that 13 shrubs need to be planted at $15.99 a pop in order for this buyer to go forward and buy the house without having to take care of that once they move in. So again, it doesn't eliminate the seller's ability. The seller can't say, I didn't tell anybody, so I'm free and clear. They're not. If the sellers have misrepresented or not conveyed the truth about their status, they could be in trouble. Paragraph C talks about fees. Please do not put 50-50. That fill in the blank has to be a dollar amount. It says so. And you know how I know? Because a dollar precedes that blank. That's how we know there has to be a dollar amount. And it can be a value of 0.00, right? That's a value. It's nil, but it's a value, but not blank, okay? So I know that. Not TBD, to be determined, and not 50-50 split. Okay, those are not appropriate there. Number D, deposits and reserves. Buyers shall pay any deposits for reserves required at closing by the association. Some buyers in the past thought that all the seller's reserves got to transfer to them when they acquired the property. So they were under the misimpression that that was their money. It's not. It's the seller's money. So they put it in a paragraph so we'd all understand that. And then paragraph E is that authorization paragraph that was notated in bold after 4, A1, 2, 3, and 4. And it says, seller authorizes the association to release and provide the subdivision information and any updated resale certificate if requested by the buyer, the title company, remember how the title company has to have it, or any broker to the sale. If buyer does not require the subdivision information or an updated resale certificate, And the title company requires information from the association, such as the status of dues, special assessments, violations of covenants and restrictions, and a waiver of any right of first refusal. Buyer or seller shall pay the title company the cost of obtaining the information prior to the title company ordering the information. So one of these boxes must be marked, period. Yes?
Marilyn, lots of times when someone sends this to me, they overlook that. So I put it in my client's favor, I have them initial it, and I send it back to have the other side initial that.
Yeah.
If it's changed, is that what you do?
Yeah, if the seller receives something and this is blank, the seller can then say, well, no, I'm going to mark this box and send it back as a counter.
Yeah, I mark it as the buyer pays it, and I have my seller initial it.
It's whatever the buyer and the seller agree to. They're going to negotiate. If the buyer comes back and says, no, I want the seller to pay it, then they are negotiating. But you don't let it be blank. That's the problem for you. One of those boxes must be marked. Yes?
Is there any chance that they're gonna change this to a blank in the future? Because this fee, I've seen it vary widely.
Sure. Oh, yeah.
I've seen it like $300 because they're trying to force more things than you're asking for, but the management company doesn't give you a venue to just get the resale certificate.
Well, if you notice paragraph C, except as provided in paragraphs A and D, it talks about money. In this paragraph, E is the authorization that somebody's going to pay for it. And a seller already knows how much it costs. Most of the time, buyers need to do their due diligence and find out how much it would cost before they present an offer, okay? Sellers already know. Everybody knows when they live in an association how much it costs to get these things.
In my experience over the last 2 or 3 years, management companies have gone from charging $100 to $300, and you can only go through their website.
Oh, yeah.
It's a big change.
Oh, I know. Oh, I know all about it. Title companies. This is a title company paragraph, so this is what they're taking care of. But make no mistake, somebody's paying for it. The title company is not. And that's what this paragraph is about. It's the authorization to get those money and charge that party. Yes?
You know how subdivisions are supposed to approve any of your additions and whatnot? In our subdivision, I know a guy who put in a nice beautiful patio, but he didn't want to bother with the association. He just did it without approval, and it's gorgeous. So when he was ready to sell his house, will that be a problem if it never got approved?
Oh, yes, it will be a problem. Those HOAs are wonderful. They usually, here's what happens. If they dawn you because it's something obvious, the seller has been told about it numerous times. In this event, now they send somebody out that is their compliance person for the HOA, and now they inspect the property before they finalize the resale certificate, and that's where all of that information resides. That's why that resale certificate is so important to a buyer, because it'll reflect that there's some issues, or I'm accepting this property with those conditions and I understand all of those things. Now, I'm going to tell you that this, again, this is a buyer-driven document. This is not a listing document. It's not a listing agent and a seller being able to sit in the back room somewhere and say, we're going to cram this down the buyer's throat. This is a buyer-driven document. The buyer has to read it and say, this is what I want, and the terms I want, and present it to the seller. The seller can certainly counter based on what your negotiations are. That's not about that, but I am going to tell you this is a buyer-driven document. Do not have this document in your listing folder, because you're going to get another notch in my book. And that's not what you want. As I said, you can hide it in your own arsenal. Just make sure it's not a broker file. Okay, that would be the hard thing for us, is if we continue to have them. Now, the next thing that nobody takes care of this, and this is a federal form. This is a lead-based paint addendum. This is in compliance with the federal government. Okay? Is it attached to the contract? Absolutely. It's in paragraph 22. So here's what happens to you guys. You don't turn your listing in timely. You turn your listing in when you get a contract. We see in the listing that the seller hasn't filled in box B1 or B2. Well, the seller can't give an incomplete form. This is a seller-driven document. Seller has it because it's attached to the seller's disclosure, okay? So what happens is the seller has to tell a prospective purchaser by federal law. The reason I keep saying this is they're hitting Texas. They're up in North Texas. They're going into the offices. And in the event this form was improperly done at the wrong time, it has to be done prior to offer, has to be attached to the contract before it's executed, the broker and the agent are being fined $11,000 per time. It's going to destroy and wipe out most offices, because I'm going to tell you, out of the almost 3,000 agents I help, 2 get it right. That's bad. And I'm telling you, this is a listing document. This is attached to the seller's disclosure. So what happens on this form, the federal government said, seller, you have to complete what you know about the presence of lead-based paint, checkbox B1, A or B, and B2, and provide any reports or anything that you have. And you have to give the pamphlet to this prospective purchaser prior to offer. That's what the seller is required by federal law. So, who gets to do that? The listing agent. You better have that PDF pamphlet, and you better send it over when you get an offer, okay? Because now you have delivered it per federal law for the seller, okay? No, you cannot just upload it. That's not called delivery, and that's what the attorneys define. Delivery is you as an agent, representative of the seller, you did what you were, the seller was required. Uploading it and having it for them to reference is not the same as delivery. You are going to be charged with delivery of it, not just saying, oh, go back up there and do that. Now, once your buyers, remember how buyers have to receive, per the statute, the seller's disclosure prior to offer? That's the law. Our contract said, we understand the law, and now we're going to give the buyer a big, big walk if the seller didn't do what is required by law. Okay, so we have a little contingency already built into our contracts. But this is required to be attached to the seller's disclosure and delivered prior to the executed contract. This has to be done prior to offer. Now, the buyers are going to look at, yes?
You're saying we've got to get it before we receive an offer, but we don't always know we're going to get an offer until we get the offer.
Well, I understand that. But the moment you have received an offer, you must send this over and the seller's disclosure.
Executed is okay.
Pardon me?
Prior to executed is
Yeah,
okay.
it has to be prior to the executed contract. And basically, the statute says prior to offer. But in this case, you would definitely, if you were a listing agent and the buyer agent didn't give you a heads up that they're going to be putting an offer on your property, you would send over these documents immediately, because you don't want negotiations in the contract to be at a detriment to your seller because 7B is an issue of not delivery of. Oh, yeah. And she was asking that if the listing agent fails to deliver this lead-based paint addendum, do you ask for it? Yes, because only a buyer, by federal law, can attest what the seller has already marked. You as a buyer's agent couldn't have the buyer mark their box as C and D because that's not applicable. The form is mandated by federal law that the seller must mark and provide the information in the pamphlet prior to the buyer acknowledging. No, it says prior to. Yeah, prior to 1978. Now, what happens when you as a buyer's agent receive this and the seller has marked box B1, A or B, and B2, A or B, you're not going to have your buyers acknowledge it if it's not been marked properly by the seller. Do you understand the difference? Okay, so you have to look at it. So if it's not done right, you're going to send it back to the listing agent and said that please have the seller mark the boxes B1, A or B, and that type of thing. You don't want your buyers to acknowledge an incomplete form, and especially one that's mandated by federal law. And the reason I'm getting so onto this is because when the attorneys who represent us were called to North Texas up in the Dallas area because the investigators have come on premise, they've required the broker to open up all their files. And they go through all of them. And they're going to wipe out the offices. They could wipe out this office in one afternoon. Oh, they could. Yeah, I'm not kidding. So that's why I'm kind of trying to make sure you understand. As a listing agent, you should know your job a lot better than this. You don't turn over an incomplete form to a prospective purchaser. That's very deadly for you. But as a buyer's agent, don't let your buyer sign a form that is not complete. Okay, so just remember that. Now, paragraph C and D must be marked by the buyer. That's how it works. The buyer gets this form, they see what the seller told them, they may have attached reports and that type of thing. They have received the pamphlet and now they're going to acknowledge exactly what they know. They're either going to waive the opportunity to do a risk assessment for lead-based paint, or within 10 days after this contract, they're going to do one. Okay? Paragraph D, buyer acknowledges. Buyer has received copies of all the information listed above. And D2, buyer has received the pamphlet. Okay? So a buyer's not going to mark this box. And let me tell you, D2 always has to be marked. No ifs, ands, or buts. D1 may be marked if the seller provided some kind of lead-based paint assessment that they had on their property. Okay? So if a seller has already had an assessment, they would attach it, and then the buyer would acknowledge not only D1, but D2. But D2 must always be marked. Otherwise, you violated the federal law. Okay? So we don't want that to go. Yes?
D1 is only marked if the seller provided
Some risk assessment, a lead-based paint report. Any reports they have that they notate, that they have reports and records available, and that they do have it, A or B, or they have no reports. They usually know.
But you're saying it's our responsibility to get the continuation and seller's disclosure to not oversee this?
Yes, it is required. The seller is required by law. Yep. So,
Sending the pamphlet is required even if it's built beyond 78?
no. It's only applicable on properties built prior to when? 1978. Yeah, so you don't give it when it's not applicable. Yeah.
I've got a stupid question. What if the home was built prior to 78, but it was gutted, taken down to the studs?
If it was built prior to 1978, you must attach this, no matter what, no matter what, no matter what. There's a record somewhere saying that it was built prior to 1978, so that's the problem. Yes, ma'am.
When I'm working with a buyer and we're putting in an offer on a house prior to 1978, I send the pamphlets, so they know in advance what they're getting into. Is that sufficient, or do I?
You can use, as she's talking about as a buyer's agent using the pamphlet, you're free to use that, but the federal law requires that the seller deliver it. That's why the listing agent has to prove they delivered it for the seller, okay? I have 5 more minutes here, and we turn into a pumpkin. Okay, real quickly, do you want, it's going to be really, really fast. Do you want me to do the short sale addendum or the addendum for sale of other property? I think we're going to do the addendum for sale of other property. I see that more often. Okay, but listen up real quick. Now, this is one of those situations that it's very deadly for a buyer in the event that they have this addendum. Because I'm going to read something to you that is critical that a buyer understand. A seller normally doesn't like these. Because why? It's a bigger contingency than you'll ever place on any contract. Mainly because the first paragraph, it says, the contract is contingent upon buyer's receipt of the proceeds. No, it's in bold. From the sale of buyer's property at, and they're going to list the property that they have as an addendum for sale of other property. If the contingency, and that's this addendum, if this contingency is not satisfied or waived by buyer by the above date, the contract will terminate automatically. and the earnest money will be refunded to the buyer. And I've said warning and I said automatic termination. Here's what happens. When a buyer puts this addendum on their offer to the seller, they're saying, look, my house is under contract maybe, and I'm going to get the proceeds by July 5th. Okay, so they put July 5th being the date that they should get their proceeds. Okay, many times we see this same date be the date of the closing date in the contract. So what happens is all the way up to the closing date, the buyer is okay because in the event they still don't get those proceeds by that date in this paragraph, they're okay. They can terminate and get their earnest money back if they don't get those proceeds. What happens is when you have a closing that will occur or a date that will occur prior to the closing date of the contract in paragraph 9, that's where you have the big problems. Because you negotiated for the buyer that, look, they're going to get their proceeds on July 5th, even though our closing date is July 30th. Notice the difference? On July 5th, if the buyer doesn't waive this contingency or get it in an amendment in paragraph 9 other to extend that date, the contract automatically terminates and your buyer's lost the property. Is that pretty deadly? You betcha. And has it caught the agents? Buyer's agents have been in trouble from that. Big time. How do you explain to your buyer, oh by the way, you don't have a contract anymore? That's not where you want to be. There's no win for you at all as a buyer's agent if this happens. The hard part for the listing agent is they've got to stay on top of this because they're going to pull the trigger because the seller's going to know it and the seller's going to say, you're done. You're out of here. Here's your earnest money. Goodbye. Okay. It says that the buyer's date that they place, they must have the proceeds from that sale of that property on that date or waive this contingency in an amendment by that date. Otherwise, the contract automatically terminates. Now, if the buyer has got their proceeds by that date, no problem, right? They're going forward. Pardon me?
Is that required notification?
It is. It has to be in the form. It has.
The buyer has their proceeds.
Pardon me?
How does the seller know that the buyer has closed and they have their proceeds?
Number one, the listing agent usually verifies that and finds that out. Number two, there's such a thing as called MLS. And so a lot of times they find out that way. An agent yesterday called me and I said, have you checked MLS? And they said, oh my God, no. Thank you. They went out there and checked it and it had closed. Okay. So that's how it's done as far as that goes. The problem for your buyer is in the event that they didn't get those proceeds by that date, they have to, in an amendment, waive this contingency or get the seller to extend that date. Okay, just be very careful. Those things have to be done each time. Yes, sir. Or the contract terminates. It's gone.
My question is, the funds available, but if they're selling the property to close on the 5th, and they, the date is the 5th, they may not have the funds available until the 6th or 7th.
You have to be very careful about this date. And Philip just mentioned, what if they don't have the proceeds? Are proceeds funding? Yes. That sale had to fund in order for this buyer, a previous seller, to have those proceeds. That's what proceeds mean. It's already funded. Not closed, funded. Yes.
What do you do with where the buyer's closing their sale in the morning and doing their purchase that afternoon? So they're probably, they're not going to be planning, but they're setting it up to do it both of them on the same day.
Well, and you're talking about a domino effect, what you just mentioned. They're closing in the morning for the sale of their property, and then they're closing in the afternoon for the acquiring of the buyer, acquiring the property from another seller. The problem for you is that that is never going to work. That's where the agent representing the buyer, they've got to do a much better job because you don't have dominoes. Do you know that none of those have worked very well? And we've had some that have dominoed. In other words, multiple parties have been injured because one little part didn't work right. Don't go in ready to shoot both of your feet. And that's really what a buyer's doing. They're just going to be crippled going in. It doesn't make sense. I understand timing to have a seller's temporary residential lease. I understand all of those types of things in possession. But what I don't understand is running that risk and not being able to comply with the contract. Okay, that's a big thing. You got to do a much better job. Paragraph B. Now here's the other part of this contingency. If the seller accepts a written offer to sell the property, that means it's not just an offer. It is a contract. When that seller puts that notice to the buyer that has this addendum, that seller says, I have a contract, okay? So once they've accepted a written offer to sell the property, seller shall notify buyer, one, of such acceptance, and two, that seller requires buyer to waive the contingency. Buyer must waive the contingency on or before the blank day, like the second day or the third day. After receiving notice from the seller, it's TAR 1213, and they'll send that form over and say, I have a backup contract. 1213. It says, I have a backup contract, and now you either must waive this contingency, in other words, now this is going to disappear, or you must terminate. So the seller has the right to come back to the buyer. This is what the buyer has to understand. They don't have anything because that seller is going to continue to press hard to get a backup contract with better terms that don't have a contingency. And then it says that otherwise the contract will automatically terminate and the earnest money will be refunded to buyer. So as a buyer's agent, make sure that the number of days that you try and negotiate for the buyer is more than a couple of days. No seller will let it be more than 2, but from a buyer's perspective, try and do a little bit more, and I'll tell you why. We had somebody who went out of town on the weekend. They were at the lake, not available, and on Monday they got back and found out their contract had terminated because the buyer did not give notice to the seller within those number of days that they're either going to waive it or terminate, and the contract automatically terminated because they didn't get any response. So this is deadly as far as contingencies for a buyer. Now, the other...
If you have, if you're listing and you accept, your client accepts offer with a contingency, can you keep it active?
No, that's a violation of MLS rules and regulations. You always must reflect the true status of the property.
In the contract, you can put in the
Pending show for backup.
in
Sure. Yeah, absolutely. Now, paragraph 3. Buyer may waive the contingency only by notifying seller of the waiving and depositing X number of dollars. At the bottom of the TAR 1213 form is a buyer section. The top part is the seller section. The seller says you've got to either terminate or waive, blah, blah, blah. And then the buyer can come back and they're going to mark, I either waive it or I terminate within those number of days. Otherwise, it automatically terminates. By depositing dollars. Okay, now here's what happens. A lot of buyer's agents, the buyers will say, well, I don't want to put any more earnest money down. Do I have to put anything in there? Well, the buyer's going to say, I'm going to put 0, okay, or $500. Here's what's devastating for a listing agent if they don't have this script with the seller. Okay, Mr. and Mrs. Seller, we told them they had to waive or terminate. They decided they're going to waive. They're willing to lose their earnest money and go forward, and they're going to hold you in this contract even though they don't have their proceeds and may not have that property sold. They're going to hold you to it because they can't. They're in a contract with you. Now you need to tell me the dollar amount you want to put in this little blank so that when this buyer doesn't perform, you're going to be made whole for having had your property in a contingency off of the market for 45 days. What additional earnest money do you want the buyer to pay? And this is where the buyer's agent is really going to have a hard time when the seller comes back and says, I want $5,000 additional earnest money. And that's what is the positioning power for you as a listing agent if your seller understood this, because every seller would not let $500, they wouldn't let 0, they wouldn't let anything go other than what would make them whole for having allowed this contingency to continue forward, knowing that these people don't have the proceeds and don't have their home sold. But the buyer's still in the contract, make no mistake, if they waive it. This field is really critical for a seller to put the dollar amount they really want. And most of the time when you negotiate this and the seller says either the buyer accepts this or what, there won't be a contingency. Okay, yes?
So, in the original contract with an option period of 10 days, the seller forces the decision up for termination of this waiver, and it's 5 days into the option period. Does that mean that now there's only 5 days left in the option period?
No, there's always the number of days that the parties negotiated in paragraph 23 or through an amendment. The option period and this performance are mutually exclusive. The problem for the buyer is if they don't respond to this notice from the seller, it will automatically terminate. So what happens is the buyer could choose to waive the contingency if they were in their option period. They could waive it, but they still have the unrestricted right to terminate for however long their option period is.
Does it start with a waiver?
Oh, no, no, no. The option period starts the next day after the contract. No, make no mistake. We're not changing dates here. This is what we're talking about, performance, and they're mutually exclusive on this. Now, the problem is paragraph D. This is where I've highlighted buyer's warning if they do not close after removing the contingency, because this is deadly. This is where we get to point to it so the buyer knows. If buyer waives the contingency and fails to close in funds solely due to buyer's non-receipt of proceeds from buyer's property described in paragraph A above, buyer will be in default. It's there in black and white. Nobody has to go to a court to decide. Period. They're in default. If such default occurs, seller may exercise the remedies specified in paragraph 15 of the contract. So they can either go after them for damages and their earnest money or just their earnest money.
Or otherwise, the buyer has to know.
Well, if they waive the contingency and they don't close, the seller would have to pursue specific performance. And if you don't have the proceeds and you needed those proceeds to buy that house, I don't know how a seller would ever think they're going to have anything. They could have damages, but not specific performance. Paragraph E. For purposes of this addendum, time is of the essence. Remember how important time is of the essence? Strict compliance with the times for performance stated herein is required. And I highlighted time is of the essence. This addendum is so misused and misunderstood by buyer's agents and listing agents that I know there is no buyer and seller who understands it, mainly because of the confusion. So you have to be very, very particular if you represent a party that it must have their proceeds. A lot of times they use this even though they have the cash reserve and can buy that property without selling the other property. But in the event that this buyer needs those proceeds and cannot buy this seller's property, your seller needs to know that before they accept this offer. Because this is no return for a seller. You notice how the seller doesn't get to tell you to go away unless you do not respond within the number of days. Okay? So it's very critical that your seller understand that they're in limbo. They don't have anything. They can't sign an apartment lease. They can't plan their life. This is nothing. Okay? And that's really why a lot of properties, relocation companies will never allow you as an employee to ever take this contingency on a contract on your property, ever. Bank owns, they don't allow them. And you can understand why, because you don't have anything. And that's not what a company who wants to rely upon that to do. Do you want me to keep going?
Yes.
Okay, the next thing that I'm going to talk about is the short sale addendum. This has to be attached to the contract when the seller is in a short sale situation. And what is most misunderstood by this form is the fact that this contract with a short sale addendum has an executed date on the contract, doesn't it? A lot of listing agents are misinformed. They said, oh no, we're not going to put it at the title company. We're going to sign it, but we won't execute it. That is wrong. This addendum must be attached to the contract and fully executed and receipted at the title company. It sits there waiting in a holding pattern until these lien holders give their approval. So the lien holders have this ability to say, I know the parties have agreed to a contract, I see it, it's executed in writing and receipted at the title company. The problem is the lien holders are going to be the ultimate decision and authority saying, can this sale proceed forward based on what the buyer and seller agreed to in writing. Now, for you, I just want you to know that in paragraph 23, it says that the buyer is paying the seller the unrestricted right to terminate X number of dollars for so many days, right? Now, there's two little boxes. It says will be credited to the closing or will not. Here's the problem for you. Listing agents are not very versed on this and they don't understand, but if you are putting an offer in on a property that must have the short sale addendum, no lender will let that seller have any money. So what you're going to say is will not be credited. A buyer, when they give that option fee to the seller under a short sale addendum on that contract, knows that that option fee will never be credited even if they close. The lenders like that because now the lenders don't have to pay back any money that the seller received as an option fee. Okay, so it will not be credited. That's the way to go. Now the lender's looking at it and they don't have to repay it, right? They don't have to credit it to the buyer. And they like that. But make no mistake, there better be an option, an unrestricted right to terminate for that buyer. Otherwise, you're going to have a problem. In paragraph D, the first fill in the blank, the paragraphs before that say, hey, we've got a contract, we've receipted it, it's executed, but we're waiting for the lien holders to approve it. And until they approve it, it's not done. Now, D says, if seller does not notify buyer that seller has obtained lien holder's consent and agreement on or before, it is a date. This is the date that the buyer says, I'm willing to wait, Mr. and Mrs. Seller, for the lien holders to approve it. Okay? It's a date. Here's the problem for you as a buyer's agent. If the buyer puts a date in there, say let's put the date August 1st. Okay, this is what the buyer is. The buyer's put August 1st. If they have not paid for their unrestricted right to terminate an option fee, if they have not, they have to stay in this contract until August 1st. Most buyers want to see, will it happen in a couple of weeks? I'm willing to wait this long. And oh, by the way, will you continue to show me properties? They go out, they find a property 10 days later and go, oh my God, I want to terminate that contract and I want to put an offer on this other property. If they have not had the receipt of the option fee and it is part of that contract, they cannot terminate. Otherwise, they'll be in default and they could have damages and lose their earnest money. This date is a date they have to stay in if they do not have the unrestricted right to terminate. So that's why I'm telling you that will not be credited is so critical in paragraph 23. So because most of the buyers, they're willing to wait a while and then they kind of get itchy and something comes up, some cue from the MLS and they go, oh my God, I really want this property, get me out of the other one. And we found out that the listing agent said there can be no option, period. And what happened is the buyer was going to lose their earnest money if they didn't stay in this until that date. Okay? So be very careful about that. It's very important. Now the next thing is that they talk about when this contract will automatically terminate. They didn't put it in paragraph D, but they put it in E, and they said this contract will terminate and the earnest money will be refunded to buyer if the lien holder refuses or withdraws its consent and agreement prior to closing and funding. Seller shall promptly notify buyer of any lien holder's refusal to provide or withdrawal of a lien holder's consent and agreement. Now, so the buyer, if the lien holders renege or withdraw or do all these things, the buyer's always going to get their earnest money back. Okay, that's a provision. Now in paragraph F it says if buyer has the unrestricted right to terminate this contract, the time for giving notice of termination begins on the first effective date of the contract. Okay, the one that they're waiting for the lien holders to approve. And then it continues after the amended executed date. Lien holders come back and say, you're approved. That becomes the new amended executed date. The moment the lenders provide the approval. So now we have an amended executed date. We had one originally, but now we're going to amend it. And now, and only now, does a buyer actually have to do any performance, such as inspections and those things. And that date, after that amended executed date, the option period will go for the number of days in paragraph 23. So a buyer doesn't have to go out there and do inspections and all that. No, they wait until they have an amended executed date. But the unrestricted right to terminate begins from the first effective date all the way through the amended executed date and the number of days of the option. That's in paragraph 23. So again, buyers don't have to feel pressure to go in there and do inspections and all these things because they don't have to perform until there's an amended executed date with approval. Time is of the essence on this amendment too, addendum 2. And it says, H, seller authorizes any lien holder to furnish to buyer or buyer's agent representative information relating to the status of the request for a lien holder's consent and agreement. I am going to tell you that the buyer's agents have used this and found out that the seller has never completed their package for the short sale approval. Never, ever submitted it or completed it. You know what? As a buyer's agent, you better find that out before you present an offer. You know, don't go to your buyer and say, oh my God, all this time we thought they were doing the right thing. You have the consent to do it, and furthermore, you better ask that listing agent in writing, what is the status of the short sale package for the lien holder's approval? Yes?
How do you prove that, or who do you go to find out
About what?
if they have done everything they need to do?
Because you're going to get all the lien holder's information and contact details. She said, how do you go about proving that? It's because you are required as a listing agent to provide all those details because the seller has given authorization for the buyer and the buyer's representative to contact those lien holders. Okay, so that's all the information you as a buyer's agent will have in your arsenal, and you can verify a lot of these things independently. Now, the last thing is it says, paragraph I, if there is more than one lien holder or a loan secured by the property, this addendum applies to each lien holder. We have this over and over and over again. There is a stacked loan. The primary lien holder has agreed. The secondary lien holder has not. Nothing will go through until all the lien holders approve. We have this situation a great deal when the secondary lien holder is not the same as the primary lien holder. We have it almost all the time. And even though that secondary might be for $30,000 and the primary is for $200,000, they have to both agree, otherwise it doesn't go forward. Okay? So again, as a buyer's agent, you're going to ask for the status of the sellers having completed the short sale package for the lender, and you're going to ask how many loans are there? Is there a primary and a secondary loan, and find out all the details for all of those loans. That's what you'll have to do as your homework. Again, this short sale addendum is very, very critical with lots of dates, lots of performances, and it's kind of like if this happens, then this is what the provision will be. It's not something easy, but you're going to have to make sure that you get with the parties to really have a good understanding. And do not let that listing agent say that you cannot, the lender says that there cannot be an option period. No, what the lender is saying is that the lender doesn't want to give back the option fee as a credit at closing to the buyer. That's what the lender is worried about, okay? Seller put that $200 option fee, cashed it, and has already spent it, and that lien holder doesn't want to have to give it back to the buyer because the seller's already pocketed. So that's a big difference. So your buyers will need to know that they don't want to go in this lightly. They're going to lose their option fee no matter what because it's not going to ever be credited on that. Now, the next document that we have is the seller's temporary residential lease, which we see a lot on the properties. I am going to tell you real quickly, I've highlighted some things about making sure that you got lots of fill in the blanks, but the biggest thing that I'm worried about is if you could go down to paragraph 11, special provisions. Here's what happens. This temporary lease is enforced after the contract is closed and funded, okay? Are you a part of this seller's temporary residential lease? Absolutely not. It doesn't have you anywhere on it. It's attached to the contract. It survives the closing and funding because it has terms that are specific to the nature of this temporary lease. But you as an agent are not a part of it, okay? What I want to make sure is that if you represent the buyer, and the buyer is now going to automatically become a landlord, that the buyer has to understand they're always going to get a deposit and they're going to always charge money for rent. That's what happens on leases. Now, they could choose to do otherwise, but you better have in writing that you told them. Always get a security deposit and always make them pay rent. Okay, that has to be in writing. The second thing that is critical is I want to make sure in special provisions that there is something that says landlord and tenant will meet at such and such time and date for final surrender of the property. Okay, no longer will this seller, now tenant, say I've left the keys at the agent's office, or it's in the lockbox, whatever. That's not how it works. That landlord better be nose to nose seeing their property as they are willing to allow this tenant to surrender. If there are nicks somewhere, they're going to handle it right then, and you're not going to be anywhere around it. That's how you have to do it. And this makes the landlord and tenant on notice. We're going to meet at this time. Somebody says, oh, well, they have until 11:59 that day to move out. Well, I don't know about you, but nobody surrenders property at 11:59 p.m. That's just common sense, right? I can understand surrendering it at 6 p.m. maybe, or but you're not going to surrender at 11:59 p.m. That's not reasonable. Again, this is.
Would you put, if you don't know exactly what time, on or before 5 o'clock?
I would think so. At close of business, I think that's normal.
So, okay, or or on or before.
It's whatever the buyer wants, because the buyer is attaching the seller's temporary residential lease, not the seller, which is kind of unusual because normally the sellers think they're dictating it. No, this is the buyer saying, I'm the landlord, you're going to be the tenant, these are my terms.
So what if the other agent says write it up? The buyer's agent says write that up for us and send it to us, and we can.
Well, if they're not going to do their job, that's at the detriment of their buyers that they represent. But this is the time where you meet with the buyer, and if they're a first-time buyer, do you think they can become a landlord? Absolutely not. I understand they're going to negotiate it, but you're going to have to tell them that they need to read Chapter 92 of the Texas Property Code. Even though this is a modified lease, they are still bound by accounting that they have to account within 30 days of surrender. That's the law. We don't change that. The terms are modified by which they enter in this temporary lease, which can be no better you can't have it for more than 90 days. It has to be less than 90 days. So again, the reason I have such concern is because we have first-time home buyers who become landlords immediately, and they're going to expect you as the buyer agent to hold their hand and do everything for them. And that's where your liability goes through the roof, because that's not your job. You're not a property manager. You can't address any areas of concerns for a landlord. That's not your job. That's not what you're proficient in, and you're not allowed to do that. The moment you do act in any capacity as a property manager, you're done. And so we have to be very careful because we cannot do that. The one thing I am going to tell you is that there's one more paragraph that most sellers, now tenants, have not ever paid attention to, and the listing agents didn't bring it to their attention, and it's paragraph 14. Maintenance, repairs and maintenance, and here's the sad part. It says, except as otherwise provided in this lease, tenant shall bear all expense of repairing and maintaining the property, including but not limited to the yards, the trees, and the shrubs, unless otherwise required by Texas Property Code. Tenant shall promptly repair at tenant's expense any damage to the property caused directly or indirectly by any act or omission of the tenant or any person other than the landlord, landlord agents, or invitees. So the sellers, now tenants, have arranged for a moving company to come and take their items out and move them out. That moving company causes damage. Is the tenant required to pay for it? Mm-hmm. They sure are. So it's really bad because tenants were under the impression that they didn't have to pay any of this, but they have to pay everything. The only things they're not required to pay would be those things that are in paragraph 18 of the real lease, which is part of the statute, that says you don't have to take care of any HVAC issue unless you cause them, the water heater discharge, penetration, that type of thing. So there are only 3 little things, and that would be if you didn't cause them, okay? So, but if the tenant can be construed as causing it, the tenant is going to pay for it. Now, on the second page of this temporary lease, there is a paragraph called hold over.
Well, real quick, Marilyn, when you mentioned that, because they have sold their house and have a temporary lease, if the buyer did have a home warranty, a residential service company, then the buyer's residential service company would come to play.
The landlord,
Yeah, the landlord,
Yeah.
I'm sorry, the landlord's residential service contract would probably kick in if that's
Right.
not possible, then you would pay
The-
the $60.
yeah, if it's not specifically addressed here about who would pay for the first so many dollars, or the repair, sir, the landlord's going to pay for it.
Okay.
Yeah, that's the problem. Now, the next paragraph on page 2 is 19, holding over. I want $1 million in this plan. You know why? Because I don't want you to have to call me and tell me that the seller/tenants aren't moving out. Their house is not ready. They had to extend it for their buyer or whatever. Do you know what I'm saying? Yeah. Well, $50 a day is not acceptable. My holdover fee is going to be a $500 to $1,000 a day. I'm tough. And I do that for a reason, because we've gotten embroiled in this. And what happened was the buyer agent failed to explain to the buyers that not only are they landlords and subject to the law and will have to incur all these expenses to evict somebody who's a holdover, you're not allowed to stay in the property past the termination. So I want a big size holdover fee, because otherwise they've got a tenant in sufferance, and it's going to cost this first time home buyer or landlord so much money and headache and heartache, and the buyer agent's going to be sitting there going, I don't have a response for that. So that's really, that's one thing about it. The other thing you have to be careful about is most lenders want the buyer to occupy the property when the first payment is due. And when is the first payment due? Usually within 30 days, like the first, okay. We've had some where sellers are in the catbird seat and they want to negotiate a 90-day lease back or a 60-day lease back. Let me tell you, unless you've got the lender's authority in writing before the offer, you're not going to have any lease other than what the lender has agreed to can be the term. We've had several instances where they negotiated a 90-day lease back, the sellers did. Buyer found out that their lender wouldn't allow it. Lender said, you've got to remove it. And then the listing agent went to the buyer's agent and they said, look, we're going to send this amendment that looks like we're doing what the lender wants, and then we're going to have a side deal. A side deal where we're going to still let the seller stay for 90 days. It's called fraud. Yeah, well, the lender will find out. If I find out, I'm going to tell everybody. Because there's no place in our industry for fraud. That's the one element that if you are accused of fraud, not only will you never be able to practice, you won't have any money, nor will your descendants. They're going to take it all. And we know that because we have an agent who just got a verdict from a jury that said they committed fraud. It's over for them. And the problem is that, I mean, it stops it immediately. And so no matter what might sound like this could be a good resolution for the parties, let's just do this and let the lender won't know. We understand what the lender needs in writing, but let's not do that. You will never ever facilitate that. And don't make the other party feel like they're threatening you. You just say, well, you know what, I have somebody back at the office I'm going to talk to about this, and then I'll get back with you. So, and you're going to hear it from me the same way I tell it to you now. And if we have to, we're going to call the other broker on it immediately. We had in writing that the other agent said, let's do this. Okay, I'm just going to give you a hint, a little advice. If it's wrong, don't put it in an email. Because if you have a phone conversation and somebody else hasn't recorded you, it's he said, she said. But the moment you put it in writing, it'll be used against you. And we don't want that to happen. I don't want you to ever do it. I just want you to be aware that don't put it in writing at all, just to be safe on that. The other thing I am going to talk to you about is notices, real quickly. In particular, the notice of buyer's termination of contract, this one. Okay? How many of you have ever had a buyer who terminated? Okay. Most of the time, if they terminate, and we can point to a paragraph or an addendum, and they get their earnest money back, we're cool, aren't we? Everything's great. The problem I have is when the buyer agent uses this, and there is no provision for a buyer to terminate the contract and get their earnest money back. That's what this form is for, and I'm going to tell you how I know this. Do you see this line right above the note? It says this form can only be used when there is a provision for buyer to terminate and get earnest money. I wrote that because I know that. Okay? And what happens is it says, buyer notifies seller that the contract is terminated pursuant to the following. And you notice how they mark the most commonly known contingencies for a buyer to terminate with notice and terminate the contract. But in paragraph 6, it actually gives you a little room to write. And that's always deadly. But it says, other. Identify the paragraph number of contract or the addendum. So if you didn't mark the addendum that's not in 1 through 5, or you didn't mark the paragraph, your buyer does not have the provision to terminate and get their earnest money back. They can take it to a court, but they don't have provisions to use this form. So the only form that a party is going to use when they do not have the ability to terminate the contract and get their earnest money back is going to be called the release of earnest money. And this form says, this form provides for the release of the parties, brokers, and title companies from all liability under the contract. So we just talked about when a buyer has a notice and a provision to terminate, okay, and get it. The buyer is really upset. They said, Marilyn, that seller lied on that seller's disclosure. I paid all this money for my inspections, and they lied. They knew that, and now I really want my money back for the inspections. And you're going, well, nobody's holding that money. The title company is only holding what? Earnest money. Okay. But your buyer keeps hounding this and saying, I want my inspection fees and everything. You better tell the buyer, look, the moment you sign this, you have lost your ability to go after the other party for any of your damages. You must seek legal counsel in the event that you want to hold up this release and try and pursue those damages. I can try and facilitate a request, but I don't have any legal authority. I can't make the other party do it, but I can facilitate that. But if they came back and said no, that buyer now knows they have to get an attorney to pursue it, or once they sign this, they're releasing everybody from the liability under the contract. And so we've had a lot go wrong lately. We've had a lot of sellers who thought they could terminate, and they told the buyer, go away. And the buyer said, not so fast. I want this much money, or I'm not going to release it. So what happened is they had to negotiate all those separate monies in a detailed release, get those monies, and then the restriction was They told the seller, the minute I have the monies for all my damages, I will sign this release. So again, this release is final. It says, now if you as an agent have not explained its finality to the principal that you represent, that could be your problem. Okay? Even though it says it right at the top, you have to explain that to them, because the attorneys told us that this is a document that they must always consult with an attorney in the event they don't have a provision to terminate. Okay? So just remember that. If they've got a provision to terminate, there's no problem for them, is there? It's when they don't have a provision to terminate, such like sellers. They don't have a provision to terminate. All they are sitting and waiting for the buyer to default. But they can never say, go away, buyers. That can never happen. So again, just be very mindful. A seller cannot sell their property to another party until they have this mutually agreed release. Period. They could put it back on the market and take a backup contract that would be contingent upon this release, but that's it. This form has to be finalized. All right, good people.